Who will come just now? Wait for your turn.
My instructions are to withdraw, Madam.
Withdraw. All right. Item 2, at the request of Mr.
B. Chaudhary.
B. Chaudhary, matter stands withdrawn.
I'm appearing for the respondent.
Mr. B. Singh appears, BK Singh appears for FCI. Interim order, if any, stands vacated.
Madam, another request for item number 57, Madam, of the supply list.
Yes.
Madam, this again is a bench 2 matter, Madam. Come up for the second time before, Madam. Madam,
50.
57, Madam.
It's a contempt matter.
Contempt matter, Madam, arising out of an order passed by.
We'll see when the matter is reached. You point it out.
May
At this
please, Your
point
Honor.
in time. Yes.
Lordship, I beg to mention item 41, Lord. Bill hearing.
41. Yes.
The matter may be passed over for the day, Lord.
41 at the request of so-and-so passed over for the day.
Obliged.
Passed over for 2 weeks.
Obliged.
Yes.
Maybe, Lord. For listing, Lordship, we have filed the IA, Lord, for earlier hearing, Lord.
I-
Matter relating, Lordship.
Yes. Yes. Give this slip to the court master. Yes.
May it please, Sir, Lordship. I beg to mention item 30, Lordship. We have not received instruction, so we seek some time, Lordship, to.
I appear for the petitioners in this case. No? I do not object to the seeking of adjournment, but can a date be fixed? No? Can a date be fixed?
Who, this matter is by order.
Yes, I have mentioned, but they say they do.
So if you have mentioned, why are you agreeing to the prayer for adjournment?
They say that they do not.
If
have
they
it.
say that that is your problem, we can't fix a date. Matter stands adjourned for 2 weeks at the request of Mr. Botagor. Learned counsel for the respondent, Mr. Bishwakarma appears for the petitioner. Yes.
May it please your Lordship, I beg to mention item number 29, my lord, on behalf of respondent number 4, my lord. My lord, he is having dengue, my lord, JMH Chaudhary, my lord. Kindly the matter may be adjourned for a
Sir, I
day.
am appearing for the petitioner. Consent was not taken. My lord.
My lord, I call him up.
He's suffering from
Sir,
illness.
that is
So
not- sir, date may be fixed. My lord. Otherwise,
matter stands adjourned as it is submitted by MS ST Pot appearing for the respondent number 4. The arguing counsel is indisposed. Mr. Haloi, learned counsel for the petitioner, however, submits that the date may be fixed. List again on.
maybe on 5th, my lord. As I am being outside from service.
November.
November, my lord.
6th November.
But I am being outside from service, my lord, and she is enjoying the food. That is, my lord.
Difficult to give you dates in October. The dockets are already filled up.
If possible, on 5th, my lord, we will try our best. If not, subject to convenience on 5th hearing day, my lord.
5th is not possible. 17. 17 October.
Simply obliged, my lord.
Yes.
Please, your lordship, with the concern of the other side, I beg to mention item number 25. 2 weeks time may be allowed to file a affidavit in reply.
So what is your prayer?
2 weeks time may be allowed to file our affidavit in reply, lordship. Item number.
MS so learned counsel for the petitioner, praise time for filing rejoinder. Matter stands adjourned for 2 weeks. Yes.
Maybe I beg to mention for listing of repetition, lordship, which was not listed for last 1 year, lordship. So maybe listed next week, any day. lordship.
Next week is not possible. You give you a pass your mention memo, dates will be given.
Before vacation, lordship, maybe.
We'll try. 1 year it has not been listed. You want it in 2 weeks now. What were you doing for 1 year?
Just, they are just inform.
Did
me
you
that-
file a complaint before the registry? Did you file a complaint before the registry that the matter is not getting listed for 1 year?
No, lordship, I
Then-
did not.
You give a list at a, as per the rooster, the matters will be listed. Yes.
May please, Lordship. Lordship, I have already mentioned item 41, Lordship. There is an interim that might be continued.
41 interim order will continue till the
Obliged.
next date.
May it please your lordship. Item number 28, my lord, today's date, my lord. This case, my lord, yesterday I have been engaged, my lord. Any day, my lord, for the day, my lord, I want.
Who's
to-
for the petitioner?
Well, I am for the 28, my lord, I have been. engaged.
Change of counsel
Yes, my lord.
in the petitioner.
Yes.
Mr. NJ Dr. Learned Counsel appearing for the petitioner submits that he has been engaged yesterday. Therefore, he requires 2 weeks' time to complete his instructions. prayer allowed list after 2 weeks.
Madam, I'm obliged.
Lordship, I beg to mention item 55 of today's list, Lordship. It's a contempt matter. Lordship, we were granted 2 weeks time, Lordship. The matter has come prior to the finishing of the 2 weeks, Lordship. I was informed by the petitioner. Lordship may grant us 1 week time to,
Wait for the matter to be called up.
Lordship.
Yes. Yes, who's
Malad, Lordship has directed the, my director is here, Malad. Lordship has directed this.
yes, yes, please call him.
Personally appear. Malad, here, Malad, we are required to
You are the director of social welfare.
now women and
Please,
child.
please come forward. Yes. See, this is a matter where this has been pending since 2016. The petitioner's case is that she is a person of disability, person with disability, and she applied. There was no selection for persons with disability, and it is her claim that it's a violation of the provisions of the Act. The government council who appeared said that no, that's not correct. There was a selection. There were people who were selected. She did not score the requisite benchmark, and therefore she was not selected. But then the records and everything is not here. The affidavit available on record maintains the stand that for that year there was no selection. So since the submissions and the averments are contradictory, we thought the best person to explain would be the director of the department. So
But,
please tell us what is the position as to why the petitioner's case or was not considered, or whether there was any consideration of these persons with disability category. And then I'm told that the records are seized by the ACB. Now, if they're seized, then you have the liberty to go and extract the relevant records and point it to us, photocopies if you want.
May I submit, Malad? Malad, we have approached the authority, Malad. The IO is Malad, in connection with another investigation. He is out of station. They have asked for 3 days time. Malad, that record will come. Kindly give us 1 week time, Malad. And some records we have, Malad, along with the other whatever record we receive from the IO, Malad, will come up, Malad. We have understood the matter, Malad.
See, don't take it that we are annoyed with your
Correct.
performance or anything like that. We wanted the instructions in a clear manner.
Lord.
It was not coming.
Malad.
I'm sorry to say. Considering that you are here, we would also like to offer a suggestion that perhaps you can think of deputing a competent officer of your department to be in court, in benches where your matters are there, because there are several matters where instructions are lacking. So at least the orders of the court can be communicated, the instructions can be handed over to the counsel concerned who's appearing. So there is no gap of communication. So you think over it. We are
Yes,
not ordering you.
Yes.
You think over it. If you think it is possible to do it, you may look into it and make the necessary arrangements. So, yes, Mr. Monto.
No doubt this case displays a very pathetic sin regarding the act of the department, how they have been dealing with the matter.
So now
Way back in 2020,
they
December,
have placed a letter from the superintendent who's praying for 3 days time.
that is what I want to point out. Way back in December 2020, that lordship today, what has fallen from your lordship, that was the order granted to them. And thereafter, they are coming up with one plea or the other. They have not been able to do that. Let them-
Are you sure in 3 days time
Yes.
you'll get it?
But whatever document we have asked for, they said that within 3 days the IO will come and he will give us the copy. Well, with the copies and the records available in our office, Malad, we will come up. Malad. Lordship may,
We are fixing it on 13th,
Lord,
Friday.
Malad.
By this time you get your records, whatever is to be placed, you'll place it.
Lord.
We are dispensing with your personal appearance for the time being, but please ensure that you will depute a competent officer if required to address the court in respect of the instructions which are sought for, if required. Yes, Mr. Mondo, on 13th.
Yes, my lord, let it be the penultimate day. No further sums should be
Yes,
given to
yes.
them.
Heard, learned counsels for the parties in terms of the earlier order dated 22/09/2023. The Director of Women and Child Development, Government of Assam. May I know your name, please? Mr. Bibhas Modi is present before the court. Stop. Mr. D. Nath, Senior Government Advocate, Assam, is also present in court. A copy of the communication issued by the Superintendent of Police Vigilance and Anti-Corruption, Assam, to the Director of Women and Child Development is placed before the court, wherein the Superintendent had requested for 3 days' time to furnish the relevant records. Stop. It may be mentioned that the records pertaining to the case are stated to be in the custody of the Directorate of Vigilance and Anti-Corruption in respect of an investigation being carried on. Stop. In view of the submissions made by the learned senior government advocate that these informations and relevant copies of the records will be available from the Directorate of Vigilance and Anti-Corruption, this court defers the matter, allowing time to the department to complete their instructions and make necessary copies thereof. Stop. Mr. Mohanto, learned senior counsel, assisted by Mr. N.M. Hazarika, submits that umpteen opportunities have been granted to the department, but on every date, the department comes up with some excuse or the other. Stop. This court makes it clear that the matters will stand deferred till 13th of October, on which date the respondents, namely the Directorate of Women and Child Development, Government of Assam, will furnish the necessary records pertaining to the claims and contentions raised by the writ petitioner. Stop. If the instructions as prayed for to be submitted before the court are not placed, no further adjournment will be granted. Stop. The personal appearance of the director is dispensed with for the time being. However, he is directed to depute competent officer for assistance of the court on the next date fixed along with all relevant records. Matter stands adjourned and is fixed on 13/10.
But I have small submission. But the persons with disability thing, now the department, the directorate has been segregated. Earlier social welfare, now it has been segregated. This persons with disability, now it comes under the Directorate of Social Justice and Empowerment. This particular selection of 2016 was conducted by this director. That is why we are here. But the director of as on today, that is the another director that is dealing with
That we'll see, but we are concerned with the selection which was conducted in 2013 or 14.
I'm indicating that, and the second thing is if the available records, if suggest that we should bring it on record by filing an affidavit, that liberty may be given to us.
That liberty will consider on the next date if required.
Lot.
You produce the relevant records.
Lot.
Whatever relevant records you think, we are putting you to notice that no further adjournment will be granted.
Correct. That is why, if necessary, if so advised,
no further adjournment will be granted for seeking instructions. Yes. Matter stands adjourned. Matter be listed accordingly on 13.
Right.
May I prelude? This is regarding appointment of the petitioner as Gaon Pradhan, my lord. His Deputy Commissioner Nagaon, he issued an advertisement for appointment of as many as 82.
You were selected or not
I
selected?
was selected, my lord.
Selected.
I was selected.
Then what happened?
After selection, no appointment order was issued, my lord.
No appointment order issued.
Yes, my lord.
In the list
Selection
at
list
page
is,
32,
page 29 is the selection list, my lord.
page
My-
29.
29.
29.
My name is at serial 4.
Serial number 4.
4. Faizul Islam, my lord. Then, having got no appointment order, I was searching in the Deputy Commissioner's office. Then I came to know about one writ petition was filed by another person challenging my appointment. And subsequently, he withdrawn that writ petition also. My lord.
Where is that order?
Page 33.
33.
Page 33.
Yes.
Page 34 is the order.
Yes.
He had withdrawn this order, writ petition. So thereafter also.
Perhaps he has filed it again. Liberty
No,
was granted.
No, my lord. No, till now, no. Any,
Yes,
I have got
Mr.
no any notice.
Mr. Dotto, any instruction?
1 year has gone, my lord, already. I am waiting for appointment.
Who's appearing?
Lordship, I am appearing for the Deputy Commissioner, Lordship. I shall obtain instruction.
All right,
Lordship.
heard.
My
Learned
lord,
counsel for the petitioner. Issue notice returnable 4 weeks.
1 year has already gone, my lord. That may be fixed, my lord.
This matter pertains to
Otherwise,
payment
my
of
lord,
Gambura,
I
of the
pray
petitioner.
to-
It is submitted that he was appointed as a petitioner. He was appointed as a Gambura of which village? You are
Number
appointed.
8, Nish Pakamari.
No, God.
Under
Niz Pokhimar,
Nagaon Sadar
Moria,
Revenue Circle.
under
Niz Pakhi
Nagaon Sodor Revenue Circle. So, these name appeared in the list of selected candidates published by the department within bracket annexure 6, page 29. However, appointment orders have not been issued, although other similarly situated persons have already been appointed. It is submitted that initially a writ petition was filed challenging his appointment ID WPC 7235 of 2022. Stop. This writ petition came to be withdrawn on 21/11/2022. In spite of that, no appointment order has been issued. Representations filed by the petitioner has remained pending till date. You obtained your instructions?
Lordship, I shall.
Yes.
Date
After-
may be fixed, my lord. My lord, date may be fixed.
Yes, yes. After 4 weeks, give a date.
Uh,
Since learned counsels appear for the respondents, extra copies be furnished. Notices of waiting. Yes, 10 November.
10 November.
My lord, in this case, my lord, after death of the petitioner's husband, lordship, she submitted representation lordship for compulsion and appointment lordship. Kindly see page 44 lordship. Last, my lord, the deputy commissioner, my lord, directed the executive engineer to submit, my lord, a proposal before him lordship, before the ELC for consideration. My lord, page 44. My grievances, my lord, that the matter may be directed to be placed in the ELC, whatever my lord decision is taken by the DLC, that will be as per law lordship. Now, page 44, this was on 5/1/2021. This is the last communication lordship. Deputy lordship, the petitioner praised lordship.
Heard. Learned counsel for the petitioner. This application,
My lord,
writ petition file.
may I submit?
Yes.
My lord, this is the case
Hmm.
where initially she applied in 2006.
Hmm.
Now we are in 2023.
So what are your instructions?
No, it is the first date, my lord. Instruction, I am on law, my lord.
So how can you decide on the law without the facts?
Facts is, my lord, facts is before your lordship. She applied in 2000. If we go by Ajit Ranjan, my lord.
Therefore, you get your instructions. What is the state? What it is possible that you are correct and it has been rejected.
My lord. Only.
You will issue notice. It
My
will
lord.
facilitate obtaining instructions. Heard, learned counsel for the parties. This petition is filed by the petitioner. Praying for a direction to consider a case for appointment and compassionate ground. In spite of that, our case has not been considered. Representations issued have remained pending. Representation in pursuant to representations issued, our case was sent to the Office of the Executive Engineer, PWT, Patodrova, by the Office of the Deputy Commissioner, Nogao, requesting for submission of the proposal. However, no action was forthcoming from the Office of the PWT, Executive Engineer, Patodrova. Accordingly, red notice we issued. Returnable 4 weeks. Mr. Aadhar appears for all. 1, 2, 3, 4. 1, 2, 3, 4. MSM Bhattaji for 5 and 6. Since learned counsels appear for the parties, notices are waived. Extra copies be furnished within 1 week from today. Yes.
My lord, this also relates to the appointment of the petitioner as town provident, my lord.
Okay, similar order.
Samaguri
What is
administrative, my lord,
where is the select list? Where is the select list?
My lord,
Select list.
selection list page 23.
23. Where is your name?
24 in page 24, my lord. 19.
Page 24.
19, my lord.
Petitioner was selected and for post of Gaumpuda in number 6, Khanatup/Jiumari Gaon under Khatwal Moza of Samaguri Revenue Circle.
My lord, here some your lordship's order is there at page 59, 58, 59, my lord. Another one challenge this his appointment also in this case, and her repetition was disposed of by this order with some specific direction to submit appeal before the appellate authority under executive.
Your appointment order issued or not issued?
Not issued in mind.
Not issued.
Not issued.
Is it under challenge before this court by any
No,
person?
no, no. That earlier it was challenged in that petition. That petition was disposed of by your lordship's order.
So your grievance is that you're, in spite of your name being in the select list, no appointment order is issued.
No, not.
So let them obtain the instruction. This disposal is in reference to, I think, where it was. His eligibility was rejected. Come to page number 59.
My lord, that is, I have submitted some certificate to that effect that I am not a member of any political party. That certificate I have annexed to my.
Mr. Counsel, you're selected. Are you selected or not?
Selected.
You're selected. So this order is in respect of a person who was not selected. Therefore, the petition was disposed of with a direction to file an appeal.
My lord.
Your case is not similar to this. Issue notice, returnable 4 weeks. Mr. C.S. Rudwa appears for. You appear for whom? Deputy Commissioner?
Deputy Commissioner, my brother will be for one.
Deputy Commissioner and Circle Officer.
Yes, sir.
And Mr. Doctor for number 1. Steps on respondent number 4. Who is respondent 4?
This earlier petitioner, my lord. Earlier petitioner.
Steps on respondent 4 within 1 week from today. Extra copies will be furnished.
Well, that
Please, both the matters will be listed together. I want to know. Yes. Both the matters will be listed together.
Together.
Possibly.
Not together.
whether the petitioner had participated in a selection process for the post of constable general duty. And my lord, he was rejected on a medical ground. Lordship would find it page 37A.
Yes.
My lord, will find that serial number 1, just before the, just after the names and the photographs. Reasons for medical unfitness, Lordship will find bilateral carrying angle more than 20 degrees. Now, if Lordship would kindly have the next page, page 38, my lord, when I went to get the medical remedical done, Lordship will find that the Fakhruddin Ali Ahmed Medical College has given me a certificate saying the carrying angle of both the elbows are within normal limits, that is WNL at the end of the sentence. And at page 39, Lordship will find, based on X-ray reports, the carrying angle has been found to be 15 and 14 degrees. Their very own guidelines at page 46 would show that carrying angle between 10 to 15 degrees.
What is a carrying angle?
My lord, the hand when placed like this angle is called the carrying angle. If it is too much of a, the angle is too much, then it may hit the other person while running, or if it's too less, it may hit the person himself when carrying a gun. So they calculate that, but it has to be done on the basis of the X-ray findings. Now their rejection at page 37 doesn't show.
What is the criteria of the department?
My criteria of the department, then Lordship will find it page 47. I'm sorry, my lord, page 46.
Yes.
Clause 2A, the last sentence, third last sentence of clause 2A. For example, in case of unfitness due to tachycardia, it should be written pulse rate so and so. Carrying angle 18 degree, normal range is 10 to 15 degree. So I have 14 and 15.
Within normal.
I have the normal range, my lord, but they say it is more than 20 degrees. Since it's a mathematical calculation to be done on the basis of an X-ray finding, we can have the.
This finding was, where is this finding reflected?
My lord, the finding is reflected. Page 37 is their finding. Page 37A.
Carrying angle of more than 20 degrees.
They say it is more than 20 degrees. Whereas, my lord, on the on page 39, for the X-ray report, it is 15 degrees and 14 degrees.
Now, this subsequent medical is at your own instance.
At my cost, madam, because they did not do it for the X-ray findings, and Lordship will find at page 58, which starts at page 56. The guidelines for the review medical board at page 56, it starts. At page 58, clause I, Lordship will find page 58, clause I, Nopni, Bole, cubitus, valgus, various deformities, X-ray plate with findings have to be taken in. My lord, whenever there is a deformity in the bone to be assessed, it has to be supported by X-ray findings. Now, my X-ray findings show that it is 14 and 15 degrees. Their eyesight says it is 20 degrees. At best, I'm entitled for a review medical examination, unless they can show from records that their X-ray findings are to some other effect.
A hard learned counsel for the. Yes, madam, anything?
Lordship, first I have to verify whether this medical uniform guideline is still in operation or there is any subsequent.
It's on page 55 is the present one. Present one is at page 54. That is dated May 31st, 2021. This is in force, and therefore I depend upon page 58.
Hard learned counsel for the petitioner. This writ petition has been filed with the petitioner aggrieved by the fact that he was not selected by the authority. He was not selected in the selection process which was carried on for the appointment, selection and appointment to the post of Constable General Duty in Central Armed Police Force. Stop. The petitioner was declared to be medically unfit. Stop. Learned counsel for the petitioner submits that the medical board during the process of the selection held that he was unfit as, within quotes, italics, carrying angle is more than 20% with movement restriction on both elbow joint, page 37, capital A. Pencil mark portion. It is submitted by the learned counsel for the petitioner that subsequent thereto, he had approached the authorities requesting for a review medical board, but that was declined.
The review medical board was done, my lord.
It was
Review
done.
medical board, they say it is 20 degrees on the same day.
This finding is review medical board.
37 is, there are two findings. The serial number 1 is reasons for medical unfitness, and serial number 2 is brief of review medical examination and finding thereof. They
No,
come to the same finding.
No, review is what? 37A is review.
37A.
Yes, review.
Yeah, review.
Where is the original medical?
My lord, that lordship will find at page 37 is serial number 1 only. They just noted it down. They did not give it to me.
Okay, you write in the medical, he was declared unfit because of this. And he was declared unfit because the medical board held bilateral carrying angle is more than 20 degrees. Subsequently, a review medical board was conducted, and the review medical board also concurred with the finding and gave the opinion that the carrying angle more than 20% with movement restriction on both elbows. This is page 37A. Stop. Learned counsel for the petitioner submits that subsequently he underwent medical examination before the Fakhruddin Ali Ahmed Medical College Hospital, Borpeta. And there, the right carrying angle is found to be 15 degrees and left carrying angle is found to be 14 degrees. Mr. Mazumdar, learned counsel for the petitioner, referring to the
Uniform medical guidelines.
uniform medical guidelines for recruitment in the Central Armed Police Forces and Assam Rifles. At clause 2, is it 2?
2-1. 2A.
2A1, it is said, it is mentioned that carrying angle, normal range of carrying angle is 10 degrees to 15 degrees.
And at
Stop.
page 52 also, my lord, they say up to 20 degrees. Page 52, serial number M. 7M.
Page 52.
Serial number 7M.
Clause 7.
Candidates with carrying angle up to 20 degrees.
That apart, at clause 7, under the head minor acceptable defects, it is shown that at clause 7 within bracket M. Now you write at clause 7 under the head minor acceptable defects. It is provided at subclause M that candidates with carrying angle up to 20%, 20 degrees may be accepted. If the same is associated
Is
with
not associated, my lord. That not word is missing. my lord. Not associated.
if the same is not associated. You write, you stop at the carrying angle of 20% may be accepted. Stop. Learned counsel for the petitioner submits that medical examination conducted at the government medical college reflects that his carrying angle is less than 20%. Whereas the review medical board has arrived at a finding that it is more than 20%.
20 degrees.
20 degrees, sorry, 20 degrees. Stop. Under such circumstances, he submits that a special review medical board be constituted for reviewing the medical condition of the petitioner. And till then, and if found fit, he should be considered for appointment. Stop. Para MS B. Sharma, learned CGC, submits that she will have to obtain instructions as to the latest guidelines for medical boards and review medical boards. Accordingly, let notice be issued, returnable 4 weeks. Since the learned CGC appears for the respondent, notices are waived. However, extra copies be furnished within 1 week from today. List after 4 weeks.
Although the appointments may be subject to outcome, otherwise they come up with a plea that we don't have a procedure.
In the event the petitioner is found to be fit, medically fit, court will consider passing appropriate orders directing appointment of the petition.
Publish.
Yeah, please, Lord.
Yes.
My lord, this is a matter relating to my lord from repulsion of from the post of assistant commandant to my lord Provident in Central Reserve Police Force. Now, my lord, the petitioner was promoted, my lord, in the 2016 to the post of my lord assistant commandant ministerial. So, my lord, and the promotion was, my lord, for probation of 2 years. And the condition is that, my lord, the person has to be, my lord, under the category of medical category of SAFE 1. So, my lord, during his probation, my lord, it is not come under category of SAFE 3 due to his diabetes, my lord. So during that probation period, my lord, under medication, my lord, after taking proper medication, my lord, petitioner condition, health condition become again, my lord, in SAFE 1. So he applied for premature medical review board, my lord, before the authority. And authority, my lord, duly approved for his premature medical, my lord, review board. And accordingly, he was examined by the premature medical board review, my lord, and recommended again under SAFE 1, my lord. Then authority, my lord, in 2023, my lord, without considering.
What is his prayer now?
My lord, my prayer is, my regarding, I am challenging that, my lord, reversion order, my lord.
Where is that order? Impugn order?
Impugn order is, my lord, at page 99, my lord. Operative part is, my lord, page 101, there are 8, my lord.
What is LMC?
Low medical category.
Yes, what do you say?
Lordship, due to low medical category, lordship, permanent low medical category, he was reverted to lordship Supervisor.
Where is the finding permanent low medical category?
Lordship, in the page 99, lordship, it is clearly stated in the order.
On what basis? This finding is arrived at on some medical report. Where is that?
Lordship, as per the review departmental committee, lordship, page 11, 100, lordship.
Page
Page 100,
100.
paragraph 4. And for deciding the review, DCC recommended that the officer is unfit for retention in the present post of assistant commandant ministerial, as the officer could it regain SAFE 1 medical category even after completion of double the normal probation period, and was medically categorized in previous review medical examination as SAFE E3P, that is 17/3/22. The review medical examination lordship, he was found SAFE 3, which is LMC of permanent nature.
Lordship, pre-medical board review board report is, my lord, at page 92. Page 92, my lord. Lord, column 7. medical category recommended, my lord, T1. T1 is the safe one.
E1 is,
The safe one.
uh,
And my lord, earlier I was in the safe 3, my lord. So safe part is considered, my lord, it is accepted for recommendation for promotion and confirmation of promotion. And this is the, my lord, report submitted by the, my lord.
no,
medical-
where have you brought to low medical category? By which order? By which medical board? By which
No, when-
medical
what happened
review?
after promotion, my lord, there is a
Ah.
rule in this organization. So annually, my lord, they are medical.
Where is that medical report? That's what
My
I'm
lord, that
asking.
report is there, my lord. My lord, medical reports are, my lord, starting from
All right, heard learned counsel for the petitioner. This writ petition is filed with the
Yes,
petitioner
69.
aggrieved by the fact that he was employed as assistant commandant of group center CRPC Khatkati, stopped by the impugned order dated 17th April 2023 because of purportedly low medical category. He was brought down to the rank of Subedar Major within bracket mini under the provisions of Rule 108 within bracket 4 of the CRPF rules 1955 read with para 10.6.8 of the CRFT establishment manual. This order was passed upon the conclusions arrived by the competent authority that he remained under low medical category of a permanent nature after completion of double of the normal provision period within bracket 4 years. Stop. Learned counsel for the petitioner submits that the findings arrived at in this impugned order are not correct and they are not based on proper medical reports and appreciation of correct facts. He submits that earlier he was under the low medical category. Subsequently, he has been brought into L1,
safe 1.
shape 1.
Lordship, this is also replied in this order. Lordship, this review, premature review, Lordship, medical examination was also considered in this order.
Yes, you obtain your instruction. And accordingly, this order of reverting the petitioner to the rank of Subedar Major within bracket mini from the rank of assistant commandant is being challenged. Para MS R. Devi, learned counsel, learned CGC appears for the respondents. Let notice be issued, returnable 4 weeks. Since government counsel appears on behalf of all the respondents, notices are waived. However, extra copies will be furnished within 1 week from today. List after returnable.
The grievance of the petitioner pertains to cancellation of her appointment in the post of laboratory technician at the Tezpur Medical College. Lordship, petitioner applied for the post of medical laboratory technician pursuant to the advertisement issued on 19/2/2011.
Yes.
And the select list selection process was completed in the year 2013, but her name was not reflected at that point of time. And some of the non-selected candidates approached this honorable court, and the honorable court interfered with the appointment of some of the candidates, and also issued a direction to the authorities for recasting the select list. And in the year 2022, the judgment was passed. And pursuant to the judgment, the select list, which was published in the year 2012, that was recasted, and the petitioner was granted appointment. But now she has not been allowed to join on the ground that the degree of laboratory technician from where she obtained from the institute is not a recognized institute. That is the issue. Lordship may kindly peruse the advertisement at page.
Recognized by whom?
Recognized by the competent authority. That is what we say.
That is?
Competent authority.
Which is that competent authority?
Probably the Srimanta Sankardev University of Health Sciences. But That is what.
Yes.
Yes, my lord. My lord, just now I obtained a telephonic instruction from the principal, my lord, that this institute is not in existence, my lord, because he got a report from the director of medical education, my lord. This is not a recognized institute, and the certificate which was produced by the petitioner.
No, recognize is one thing, not in existence is completely another thing.
Yes, my lord, because now the principal has told that it is not recognized, even that is not existent. That is a different thing, my lord. But my lord, one thing is clear that it is not a recognized institute. And in the certificate which was produced by the petitioner, my lord, before the principal for the initially, in that certificate, even there was no signature of any competent authority. Subsequently,
Then why did you put her name in the select list?
Because in terms of the direction passed by this honorable court in the writ petition, my lord, recasting of the select list was done, and thereafter, my lord, document verification was done, my lord.
Lordship,
And
may I
in that, when the document verification was done, during document verification, it has come to the light of the knowledge of the authority.
Where is that certificate?
Lordship will kindly peruse page 20 of my petition. The mark sheet.
So there is no signature.
No, there is signature. It is not. It's not legible. Lordship, it's a photocopy. The signature. We can produce the original one. Lordship will kindly see Institute of Medical and Technology Research, Vocational Training Institute for Paramedical Education, chartered by SH, government registered number. So
This is pursuant to some advertisement. You are selected.
Yes, my lord.
Yes.
Where is that advertisement?
Advertisement at page 22.
22.
This is the type copy of the advertisement.
Yes.
22. The qualification which is cited there, laboratory technician certificate course of above, equivalent from any medical college of Assam, / recognized institute of government of Assam. That is what it says. And our certificate reflects that it is recognized by the government of Assam and it is affiliated to a institute which has been approved by the Parliament, established by the Planning Commission of India.
Where is that list of institute recognized by the government of Assam?
That they will have to.
Mr. Bora.
My lord.
Where is that list showing which institutes are recognized by the government of Assam?
My lord, I will have to obtain, my lord. And my lord, on this particular point, whether this is a recognized institute or not, my lord, that I will obtain inspection.
Lordship, on the submission regards the submission made by him, that the institute is no longer in existence.
That is a telephonic.
Yes. Why they are making that submission is that because there is a change in name of the institute. Lordship will kindly peruse page 54 of my petition, the document at page 54. This is a certificate issued by the managing director of the institute from where we obtained the degree. Earlier, the name of the institute was Institute of Medical and Technology Research, and now it has been changed to Institute of Allied Health Science. That is why they are saying that the institute is no longer in existence.
But if the name is changed, how will people know it is one and the same?
That is why, Lordship, this certificate has been issued. But fact remains that this certificate has been issued. That is why, by the managing director. Name has been changed, affiliated to the same organization. Lordship will kindly peruse one more document.
My lord.
Where at page 58.
Yes.
The institute is affiliated to Bharat Sebak Samaj, and this is the National Development Agency established in 1952 by the Planning Commission, Government of India, to ensure public cooperation for implementing government plans. The main purpose behind the formulation of Bharat Sebak Samaj is to initiate a nationwide non-official and non-political.
Yes, heard learned council.
My lord, may I point out one thing?
Yes.
Page 54, my lord. The certificate that the learned council is referring, my lord.
You get your instructions.
Yes, my lord, I will obtain. But one apparent error is there. Approved by Director of Medical Education, Government of Assam, Jalukbari, Guwahati 12, my lord. My lord, the Director of Medical Education office is in Khanapara, Guwahati 22.
You are referring to which page?
Page 54, my lord.
No,
54.
no. This is Jalukbari, Guwahati 12. This is the address of the institute. This is not the pin code referred address is of the institute.
Hard learned counsel for the petitioner. This writ petition is filed with the petitioner, who is aggrieved by the impugned order, impugned communication dated 27/06/2023, whereby the petitioner was not allowed to join as a to the post of laboratory technician pursuant to her selection and appointment by order number so and so dated 29/05/2023, page 53. Stop. The appointment by the said communication, it was informed that the appointment is cancelled, as upon verification of the documents, the institute from where she had undergone the diploma in medical laboratory technician course was found to be not recognized by the competent authority. Stop. As such, she did not meet the eligibility criteria in the advertisement dated, where is the advertisement?
At page 22.
Dated dated 19/2/2011, published by the, this is for Tejpur,
Tejpur Med.
by the principal, Tejpur Medical College. Stop. It was stated that she did not meet the eligibility criteria as per the advertisement. Stop. Aggrieved, the present writ petition has been filed. Learned counsel for the petitioner submits that the allegation, the ground for cancellation is wholly unfounded, as this institute is in existence and recognized by the government of Assam. However, the name of the institute was, where is that letter?
At page 54.
The name of the institute was earlier, within quotes, Institute of Medical and Technology Research, quotes close, and subsequently it was altered to, again within quotes, Institute of Allied Health Science, quotes close, in the year 2012. It is possible that because of the change of name, the authorities are misinformed that the institute is not in existence or not recognized by the government of Assam. Consequently, she submits that appropriate orders be issued by the court, setting aside with the impugned communication dated 27/6/2023 and permitting her to join in her services as selected. Where Mr. Bora, learned standing counsel health, submits that you'd like to obtain instructions in the matter. And accordingly, let notice be issued, returnable 4 weeks, since the counsel has already entered. Mr. Bora has already entered appearance on behalf of the respondents. Notices are waived. Extra copies be furnished within 1 week from today. Meanwhile, the post in which the petitioner was selected and required to be appointed shall not be filled up without leave of the court. List again after the returnable date.
My lord, since your lordship, so a date may be fixed after vacation, my lord.
After 4 weeks,
Yes,
give a date.
give it.
15 November.
Oblige, my lord.
Yes.
Well, grievance in this petition is that the petitioner's provident fund is not accepted by the provident fund organization, stating that his Aadhar number is not linked with the provident fund account.
Yes.
I have to obtain instruction.
You obtain instruction.
So there is provision, my lord, that there is a provision that in such case.
Let him obtain instructions why it has not been allowed.
My lord.
You will issue notice or you want to obtain instructions?
Notice may be issued.
Heard learned counsel for the petitioner. The
All-
petition is filed by the petitioner putting to challenge the notices dated 17/8/2021 and 27/9/2022.
Page 54 and 57.
Whereby '54 is
Yes, my lord.
just a circular. Why are you challenging 54?
Well, yes, my lord.
Putting
If,
to
this
challenge
notice-
the communication dated 27/9/2022. Whereby the petitioner was informed that his Aadhar details has not been linked to the number of the employee in his establishment, and as such, the employer is required to pay interest at the rate of 12% per annum under Section 7, capital Q of the EPF and MP Act 1952. Stop. Mr. Chakraborty, learned counsel for the respondent, submits that you'd like to
I
obtain
appear for only 2 and 3, my lord.
respondents 2 and 3. Who are the others? You're for the Provident Fund. Union of India. Who's for Union of India? Anyone for Union of India? All right, Mr. R.K. Dev Chaudhary, learned TSG IPS for the Union of India. And 2 and 3. Who's for number 4 and 5? Since learned counsel appears for the respondents 1, 2, and 3. Notices are waived, extra copies be furnished. Steps on respondent 4 and 5 within 1 week from today by registered post 80. It's after reasonable date.
All right.
Extra copies also within 1 week.
Look, the matter relates to compassion appointment. Pursuant to a direction of this honorable court, the petitioner's application for compassionate appointment was given a consideration. Case 36 is the earlier direction of this honorable court. Case 37, last paragraph. The application is of 2015. A consideration has been given on 2019. And case 38 is the minutes of the DLC Miller, whereby the application has been rejected on the ground of non-availability of vacant post for 2 years. Now, my lord, on the date when the consideration has been given, my lord, the Office Memorandum 16/2015 is the norms, my lord, which was holding the fee. That, my lord, notification clearly provides that if there is no vacant post in that department, the DLC has to consult with the other department and has to consider for any other post he is eligible for. That exercise was not done.
Yes.
Lordship, I'll take instructions
What instructions?
as to whether an exercise was done to see if there was vacancies in other department as
It's
well.
not available in your order.
My lord, the
In the
minute
minutes, it's not recorded.
Minute itself.
That states that there was no vacancy.
Hmm?
The minutes of the meeting says that there was no vacancy by
Does not
DSC.
reflect that it was taken into consideration. The other vacancies will be available. All right, you get your instructions.
Yes, sir.
Heard learned counsel for the parties. This petition is filed by the petitioner aggrieved because of the non-consideration of the petitioner's case by the DLC for compassionate appointment. Petitioner's case was rejected by the DLC by its meeting held on 28 to 2019 on the ground that what is the ground for rejection?
But
No vacancy.
non-availability of vacant post up to 2 years.
Non-availability of vacant post up to 2 years from the date of the application. Learned counsel for the petitioner submits that on the date when the case of the petitioner was considered, the provisions of the OM dated 1/6/2015 were applicable. And as per the said OM, the vacancies in other departments ought to have been considered by the TLC while considering the application of the writ petitioner. Such consideration is not apparent on the in the minutes dated 28/2/2019. Accordingly, is approached this court for appropriate orders. There are Mr. Bodhagur appears for the respondents.
Lordship, I'm not representing DLC in this matter.
DLC will be represented by the
For
deputy commissioner.
representing 1, 2, and 3, MS M. Bhattacharya appears for respondent 4. Let notice be issued, returnable 4 weeks. Since learned counsels appear, notices are waived, steps within 1 week from today.
Right.
List after returnable date.
Lovely.
May I please, Lord. This matter pertains to non-payment of arrears salary lordship from 1/8/2017 to 22/2/2020, Lordship. In fact, there is one specific direction of this court, Lordship. Lordship, which is that page, Lordship. There is that page, Lordship 45, annexure Z, Lordship. All the petitioners earlier approached this honorable court, Lordship. And the direction is that page, Lordship 49. In view of the submission made by Mr. Gogoi, the learned counsel for the finance as well as public of department, and keeping in view the letter dated transfer issued by the Undersecretary of Assam Public of Roads.
You're working as what?
Lordship.
What are you working?
I have not been paid my.
What are you working employed as?
Lordship, master of laborers, Lordship.
Master of laborers.
Laborers, Lordship.
Under
Lordship, executive engineer, Maibung division, Lordship. And
PWD.
PWD, Lordship. And
you want the benefit of Upendas?
Upendas, Lordship.
Yes,
Lordship,
PWD.
In fact, Lordship, we are getting the same quota from Lordship March 2020. Prior to that, Lordship, we are not paid, Lordship. And due to some technical error, Lordship.
All right, obtain instructions. Heard learned counsel for the parties. This writ petition is filed by the petitioner claiming arrear wages in respect of services rendered as master role workers under the executive engineer PWD within bracket R and B bracket close Maibong division, Dimahasao. The petitioners claim that they are entitled to the benefits. They are similarly situated as the persons whose cases were considered by division bench of this court in writ appeal number 45 of 2014 within bracket State of Assam versus Sri Upendas. Learned counsel for the petitioner submits that the arrear and back wages be and other benefits are payable to them which have not been released in spite of their requests and representations made before the authority. Vera. Mr. Goswami appears for state.
Respondent one, Lordship.
Respondent one. MS
J. Gogoi,
J. Gogoi for
7.
4 to 7. Mr. Nayak for
Respondent number 3, my colleague Aadhar will appear.
Mr. Aadhar for PWD. Mr. Nayak for 2 and 6. Treasury, Finance and Treasury. Let notice be issued, returnable 4 weeks. Steps on the government councils within 1 week. Extra copies be served. 7 also. List after returnable date.
Otherwise, not the direction was clear, direction was there. It is a final contempt.
That's actually,
We'll
order
see.
was complied, partly complied.
Order is already.
We'll see.
The direction was given to the executive engineer and compliant the same, he has submitted the proposal, but other direction was not given to the commissioner.
We'll see. Let them get the instructions. Yes. Yes, Mr. Shaw.
This matter relates to supersession in promotion. The petitioner, before Lordship, is presently working as a executive environmental scientist in the Pollution Control Board. Now he is senior to the respondents number 4 and 5. But at an earlier stage, he was superseded by the respondent number 4. The issue in that case was, whether the MSc degree in environmental science is a biological MSc equivalent to MSc equivalent or not. That matter has already been settled by the Honorable Court, in an earlier repetition, where the direction was issued to place the matter before an expert committee, and expert committee appointed those are equivalent. But then he was not promoted. In the meantime, he was superseded by the respondent number 4. He filed the repetition that is pending adjudication, Now, another promotion order has been issued by which the respondents have superseded him. At this stage, I only pray that your Lordship will issue notice and also observe that promotion of the respondent number 4 and 5 shall be subject to the result of the case.
Yes.
There cannot be any.
Heard learned counsel for the parties. This writ petition is filed with the petitioner, putting to challenge the promotion of the private respondent number 4 and 5 to the post of additional chief environmental scientist
and senior
environmental scientist. Stop. Petitioner is presently employed as what?
Presently, he is working as executive environmental scientist.
Environmental scientist. Executive. What is he?
Yes, executive environmental.
Executive environmental scientist under the Pollution Control Board, Assam. Stop. The grievance of the petitioner is that his claims have been overlooked and the private respondent number 4 and 5 have been promoted to the higher posts. Earlier, there was an issue of whether the post held by the petitioner and the other respondents were equivalent or not.
Degree, degree of MSc degree of
MSc degrees, qualifications of the petitioner and other similarly situated persons was equivalent or not, and this came to be settled by judgment of this court in
the order is at page 68 in WPC
5203.
in WPC 912, this one,
yes,
68,
912
of 2011
and 6329 of 2013
and 63
6329
6329 of
2013.
Accordingly, the claim of the petitioner ought to have been considered by the competent authorities. Stop being aggrieved, he is approached this court praying for appropriate direction or order. Mr. So-and-so counsel appears for the Pollution Control Board.
Responsible number 1, 2, and 3.
No. One he appears for the forest department. I appear for 2 and 3.
Mr. Bodhakur for
Responded one.
1. Okay, heard. Issue notice returnable 4 weeks. Since the learned counsels, respective counsels appear for 1, 2, and 3. Notices are waived. Steps. Extra copies be furnished. Steps on respondent 4 and 5 within by registered post within 1 week from today. List after returnable date.
Private
Promotions. Why should we make it subject to now?
My lord, then only the my lord reply comes early. Otherwise, my lord, I'll also request.
We'll see on the next date. Prayer for interim will be considered upon after the returnable date. Let them appear. Let us see.
Let them appear.
Because
in fact,
That is a very post order.
assuming there's a vacancy available, you can be considered.
No, in fact, my lord, the earlier repetition is also pending, my lord, when he was superseded first. Now, second time he has been superseded. That is pending. Your lordship may connect with that repetition also.
It is submitted that another writ petition is pending, and both writ petitions will be listed together. Accordingly, list this matter along with
WPC 5203
5203 of
2022.
2022. All right. We listed along with it after returnable date. Yes.
May I please, your lord? My lord, the petitioner before my lord, is a person with physical, persons with disabilities, suffering from hearing impairment from my birth. Now, my lord, the government of Assam has recently initiated a recruitment process, for the purpose of filling up of the post of the grade 4 in the various categories, And accordingly, I have participated in the recruitment process, pursuant to an advertisement. My lord may be pleased to find that advertisement is at page 52.
Some matters were fixed.
Yes, similar matters.
When is it fixed? The persons with disability. Okay, heard learned counsel for the.
My lord, I have a small prayer, along with the other matters, I have already been appointment order had been issued.
No, that has been that is kept on hold, lordship.
Now, they are saying that, I need to go through the further, medical examination. For that, I have not been allowed to join. So, may I pray that the post for which, I have been selected and appointed, that may be protected, That much interim protection I am, praying for.
You go through what? Why are you not participating in the selection?
I have already participated in the every drive, every medical examination. Now, what is the outcome of my result, What is the outcome of my medical status? That has not been, made known to me, That's why, my lord, may kindly say the nature of the impugn order which they have passed at page 63, annexure 9, this is the letter, issued from the Director of Elementary Education to all the district elementary education officers regarding temporary holding of posting in respect of the grade 4 office peon and so school, Chokidar, recommended by the state level recruitment commission. With reference to the subject cited above and in pursuance of the reports of the government in the personnel department, I am enclosing here with an order in respect of the grade 4 office peon MTS and grade 4 school Chokidar MTS, recommended by the state level recruitment commission for the class 3 and class 4 post under the Directorate of Elementary Education Assam, annexure A. Now, my lord, may verify from annexure A, my lord, is at serial number 16 at page 64 is the name of the petitioner Mirza Farooq Ahmed, and my appointment order, my lord, may be pleased to find is at page, my lord, 59. In spite of the clear appointment, my lord, they have not been allowed me to join, saying that, my lord, there are further medical examination is required, and each and every medical examination I have participated, my lord, but what is the result of my medical examination, that has not been disclosed till date, my lord. That's why, my lord, my limited and humble submission, my lord, the school in which
You
I have
obtain
been
instructions.
selected.
Let
Yes,
us
I
find
will
out.
apply instruction. Yes,
We'll
Find out.
yes, Lordship. And so far the medical result, Lordship, the counsel for the health department, they can produce the record, Lordship.
You are for whom?
I am for the elementary, Lordship.
Yes. Produce the medical result. What is the state? What instructions will you obtain otherwise?
Others from my end, Lordship, it is only because of the personal department, Lordship, letter we have withholding.
Where is that letter?
That is not annexed, but it was reflected in the in order page 64
You
annex
do not
10.
have the access of that letter, my lord.
Heard learned counsel for the parties. This writ petition is filed by the petitioner putting to challenge the withholding over an appointment order to the post of what post?
My lord, it is a grade 4. My lord,
Result to
appointment order. It is a grade 4 school chowkidar MTS at Uzan Bazar Shisu Vidyalaya LP Hiranmi Ramda. Page 59, my lord.
Serial 16.
Yes, my lord. Serial 16, the
Appointment to the post of Chowkidar. Grade 4 Chowkidar within bracket MTS. In Uzan Bazar Hiku Vidyalaya LPS in the district of Kamrup Metro. Petitioner was shortlisted by the order passed by the competent authority on 30/05/2023. It is submitted that pursuant thereto the medical test was conducted. However, the results are not known to the petitioner. The petitioner is a person with disability having
hearing impairment.
Of
More than
61% in the left ear and 100% on the right ear. Sir, how will you be a chowkidar?
My lord, with the 8, my lord, nowadays, my lord, some machines can be implemented, my lord. With the, even, my lord, when visited in my office, my lord, without machine, it is difficult for, my lord, to communicate me. That is a fact.
With machine, it is
My lord,
near normal.
Once it is installed, my lord, even then he is required to give expression.
And she had participated in the special drive for appointment of persons with disability conducted by the government of Assam in respect of grade 4 and grade 3 and grade 4 posts. Para Mr. Chisti Learned Counsel appears for the
Respondent 1, 4, and 8.
respondent numbers 1, 4, and
8.
8. MS Sorma appears for the health.
Yes, Lordship.
And Mr. B. Chaudhary for
Respondent number 5, Lord.
respondent 5. State level recruitment commission. And Mr. Goswami for
Respondent number 2, Lord.
respondent number 2.
3, social justice. No,
Let the learned government councils obtain their respective instructions in the matter as to why the petitioner, in spite of being shortlisted and selected, has not been appointed. And do you have that ID card?
Yes, my lord, the
Disability.
certificate I have annexed, my lord.
Disability?
Yes, my lord. My lord, may be pleased to find is at page 42, my lord. Issued by the Ministry of Social Justice.
In spite of the disability certificate issued by the Ministry of Social Justice and Empowerment, Government of India, VID. The disability certificate, VID certificate dated 21/10/2016, where it is reflected that he has 60% permanent disability in both ears. List. You furnish extra copies. When can you get it? After 2 weeks?
After 2 weeks. Yes.
Be listed after 2 weeks. We are not issuing notice.
Lordship, my name may be shown in the cause list, Lordship, for state level recruitment committee.
Mr. B. Chaudhary submits that his name be reflected in the cause list for the state level recruitment committee. There is no challenge to that.
Yeah,
There is no challenge to that.
I came to know only from my colleague, Lordship. A copy has not been served.
Lordship, copy has not served to
I'll-
social justice also.
Who are you appearing for?
Lordship, I'm appearing for respondent number 3, social justice and empowerment department.
Social justice, please serve a copy.
Each one of
I
my
must so and so appears for social
I'm
justice.
responsible.
It will be a blowing issue for lawyers to file petition if you have to find each and every standing counsel where they are. How will it be located? You must devise must work out something to
The phone
ensure
number is
that
there in the filing section. Phone numbers are there, Lordship.
phone numbers.
Yeah. Phone numbers are there. So if you
Perhaps
connect-
you should go digital now.
Yes.
You should supply your emails.
Yes, that cannot be done.
And soft copies can be served to all councils.
Yes.
You can think over it. Yes.
May I please, Lordship? The petitioner has applied for the post of constable duty in Central Armed Police Forces, Lordship. He has successfully passed the written examination. Thereafter, he was qualified for PST physical fitness test, Lordship. After that, admit card was issued for medical examination, Lordship. In the medical examination, the petitioner has qualified in all segments, Lordship. Only the Personnel Authority declared him unfit due to law dental points, Lordship. Law dental points, Lordship. Kindly come to the page 51, Lordship, and except 7. In review medical examination board, Lordship. Para B 2, 3, B, Lordship, unfit on account of law dental points 12, Lordship. Whereas the guidelines of the review medical examination, Lordship, kindly come to the page 10, Lordship, page 61 and extra 10, Lordship, page 61, Lordship.
Yes.
And the binocular page, Lordship, 65, Lordship. Page 65, Lordship, para 7 K, Lordship. For a case of, Lordship, got it, Lordship?
Yes.
65, Lordship, for a case of dental point less than 14, OPG should be carried out, Lordship.
What is OPG?
OPG means it is dental X-ray of upper and lower part of the teeth, Lordship. Whereas the respondent authority has not done this OPG, Lordship, but they rejected the petitioner. And they rejected the petitioner, Lordship.
No, what is OPG?
OPG means dental X-ray, Lordship. I have stated in my paragraph, Lordship, orthopanogram, Lordship, is a type of dental X-ray that produces the wide panoramic scanning of dental X-ray in both upper and lower teeth, Lordship.
What is the significance of dental points?
Dental points up to 14 points is required to get pass the medical examination, Lordship. That the petition, according to them, Lordship, petitioner get the 12 marks, Lordship.
Any guidelines showing what is a dental point? How much is
Yes.
the
Yes,
accepted norms?
Yes, Lordship. Lordship, finally come to NSN 9, page 53, Lordship. And one of the page 60, page 60, Lordship. Page 60, Lordship. A candidate law for just one para below one, Lordship. A candidate will be accepted provided there are at least 14 dental points in his her mouth, and all these teeth must be sound and repairable. Thus, the minimum number of points required in a candidate will be 14. So, therefore, the petitioner went to the Termination Medical College Hospital, Lordship. Here they found all the petitioner teeth is well and fit, Lordship. So, Lordship, kindly come page 52, Lordship. Page 52, Lordship, they examined the bath. Here is given some diagram, Lordship.
Page number?
52, Lordship.
52.
52, Lordship. Can I say 8, Lordship? 52. Okay. Here they given the toothpaste, Lordship, bath upper and lower, Lordship. They nothing found any the petitioner is defective, Lordship.
What is the opinion of the?
Although they have not given the opinion, Lordship, but
Then how do you say he is not found defective? There is no opinion.
but they have given all the tooth are here. Teeth are here. 1, 2, 3, 4, Lordship.
We do not know. Some opinion will have to be given.
Yes, Lordship, but here is not.
Yes, madam, what do you say?
Lordship, I'm appearing on behalf of all the respondent. Lordship, notice may be issued.
For what purpose? Where is the order of rejection?
Page 51, Lordship. They just give you unfit review. It is a form number 4, Lordship, review medical examination. Unfit on account of low dental point. That is the. Humble prayer of the petitioner may give a direction to the respondent authority to fresh medical to constitute fresh medical board Lordship, fresh set of doctors Lordship, so that they can examine the petitioner again Lordship. While the petitioner has got secured more marks than the cut-off marks Lordship, and he belongs to the Lordship OBC category Lordship.
Where is the finding that you are not fit to be admitted?
They have not provided here, only just unfit on account of low dental point.
Where is that?
51 Lordship, page 51.
Next year one more.
Unfit.
Next year 7.
Heard learned counsel for the parties. This writ petition is filed with the petitioner aggrieved by his non-selection, by his rejection of his candidature for during the process of selection and appointment to the post of Constable GD in CAPFs. Stop. Learned counsel for the petitioner submits that the only ground for rejection of the candidature of the petitioner is on account of low dental points. Stop. Learned counsel has referred to the review medical examination report at NHS 7, page 51. Stop. It is further submitted that the petitioner also underwent dental examination under the Tejpur Medical College Hospital, which is at and the report of the hospital at page 52 annexure 8 does not reflect any disability. Stop. Under such circumstances, petitioner has approached his court praying for appropriate direction or order. MS so-and-so appears for the learned counsel for the respondents. Let notice be issued, returnable 4 weeks. Since learned counsel appears, notices are waived, steps extra copies within 1 week from today.
Most obliged.
May I please?
Yeah.
This is the case that the petitioner is the critically challenged person. He is the 40% of the motor disabled man. And Lordship will find his certificate, my lord. That is at page 15, my lord. Disability certificate, my lord. He is a case of locomotor disability. The diagnostic of the case of post-superintendent initially left lower limb with a knee stiffness, my lord. And my lord, in this regard, my lord, the central government has also issued an identity card of unique disability. That is also at page 16, my lord. What happened, my lord? He has joined in the post of agriculture development officer as per the in pursuance to the advertisement issued by the Assam Public Service Commission on 5th April 2013, my lord. Lordship will find that advertisement at page 17 and Annexure 3, lordship. And my lord, in this case, my lord, 80 posts of agriculture development officer under agriculture department was called for, my lord, to fill up the post. And accordingly, my lord, this post was only reserved for the locomotor handicap, my lord. That is, lordship will find at next page physically handicapped 3 posts.
Why was he rejected? Not selected?
I have not been selected, my lord, not considered. I am in under the zone of consideration, my lord. Only one person has been selected, my lord. As per the provisions of section.
Where is the advertisement?
Which one?
No, here he was selected, lordship.
Yeah, that point, my lord, I have been selected and I have been appointed. Now I am working as a agriculture development officer.
Now you're
my lord, lately, my lord, the
promotions.
Promotion, yes. Promotion. Next higher post, my lord. In that case, my lord, I have not been selected.
Where is the order? DPC.
DPC lordship will find at page
page 58, my lord. My lord, I am reading after the name of the members, my lord. At the very outset, the additional chief secretary come APC of the chairman of the selection board welcome all the members present in the meeting. My lord, number 8, the cadre strength of SDAO, subdivisional agriculture officer, 165. Present men in position is SDAO cadre, 64. Present vacancy in SDAO cadre, 82. And promotional retirement vacancies up to 30/11/2023, 35. Cumulative vacancy as on 30/11/2023 SDAO cadre, 117. And my lord, accordingly, after that, my lord, after this DPC, my lord, that DPC has recommended 119 persons for the promotion to the next higher post, and accordingly, after that recommendation, the Honorable Governor of Assam has issued the order of promotion of 91%, my lord. Out of 119, my lord, 91%.
Where is your name?
My name is not there, my lord.
Your name is not there.
Not there. I have under the zone of consideration. The physical handicap, since in the gradation list, my name was at serial number 106, my lord.
But there are 117 posts.
100 yes, 107, my lord.
And names recommended is 119.
19.
How?
How, my lord? That is up to them, my lord. They have selected 119, my lord, as per the list. And my lord, that post will be filled up. Last DPC meeting was held in month, and all the posts will be filled up by 30/11/2023, my lord. At this stage, my lord, I am under the zone of consideration as a physical handicap candidate. Only one person has been selected. Since, my lord, as per the provisions of the section 34 of the Act, my lord, 4 persons may be selected. Since, my lord, this post is the identified post. This post can be held only by the person's disablement of locomotor disability. My lord.
In which number is that person selected?
115.
Only Sasanga Goswami has been selected. Well, I have no dispute on his selection, man. Only he has been selected, my lord. But the provisions of the law, my lord, 4% may be selected.
Oh, yes, it cannot be.
Since that post is, my lord, why I am coming before your lordship is that, my lord. This post is, my lord, identified post, my lord. Lordship will find at page 25, my lord, and extra 5 series. This is the list of identified jobs of the government of Assam for the person with disablement, my lord. I have annexed the only agriculture department. And lordship, please turn to page 33, my lord. 65, serial number 65. Page 33, my lord, serial number 65. Extension officer, my lord. Earlier, this post was known as the extension officer. Later on, this is designated as the agriculture development officer. This is performance is a OS, my lord. OS means, my lord, kindly see the top. OS, orthopedically handicapped, includes locomotor disability. Other disabled person is not eligible to hold the post of extension officer or development officer, my lord, in agriculture department. And after this identification, my lord, the post, now only, my lord, locomotor disablement persons is eligible to hold the post of agriculture development officer, and only amongst them, my lord, selection may be made for 4% as per the provisions of the law, my lord. Only one person has been selected. Since there is a eligible person is available, I am also available, my lord. Kindly see 4%. 4%.
No, but which of these posts are earmarked? These out of these 119 people appointed or selected, recommended. Which are the posts?
This is the post for SDO.
No.
Which are the posts identified for persons with disability? Heard Mr. So-and-so learned counsel for the petitioner. This petition is filed to the petitioner.
Only one post is identified.
He's the person.
One. Anyway, notice it. I am for 1, 2, 3, and
he was appointed. He was appointed as what? He's presently serving as what?
ADO. Agriculture Development
Presently
Officer.
serving as Agriculture Development Officer under the Agricultural Department, Government of Assam, posted in
Assar, my lord.
the district of Kachar. Learned counsel for the petitioner submits that he is the fact that he is a person with disability is certified by. Where are the papers for disability?
That is Annexure 1 and 2, my lord.
Page number.
Page number lordship will find at page 15 and 16.
By the disability certificate issued by the Joint Director Health Services Kamrup, where the disability is shown to be physically locomotor disability with 40% permanent disability. Stop. He has also been issued a unique disability ID by the Government of India, where his disability is reflected at 40%. Stop. It is submitted by the learned counsel for the petitioner that a process for selection and promotion to the next higher post of
Subdivisional Agriculture Officer.
subdivisional agricultural officer is underway, and the TPC and the petitioner was within the zone of consideration, but ultimately his case was not recommended. It is submitted by the learned counsel to the petitioner that in the list forwarded by the TPC, only one person is seen who belongs to the category of PWD. Stop. Learned counsel for the petitioner submits that under the statute, 4% reservation is
4% of the total vacancy.
4% of the total vacancy is required to be reserved. However, that exercise appears to have not been done by the TPC and therefore is violative of the provisions of So and So Act. Mr. Chisti submits that he would like to obtain instructions. Appearing for the Agriculture Department submits that he would like to obtain instructions in respect of this matter. Accordingly, let notice issue returnable 4 weeks.
4 weeks.
Since Mr. Chisti appears for all the respondents.
No,
this is a-
government is.
What is the 4?
I am for 1, 2, 3, 5, and 6.
1, 2, 3, 5, and 6 notices are waived. However, extra copies be furnished to the respondent. Mr. C.S. Borua appears for respondent number 4.
In the meantime,
For both government councils, you add that notices are waived, extra copies be served.
in the meantime, one person may be kept second.
Which post?
I don't know.
The
Because my lord, only 91
the
promotion has been made.
appointment, the promotion to the post of subdivisional agricultural officer made. You write the promotions, the select list, the recommendation of the DPC made in respect of persons recommended for appointment.
That was already given effect to lordship. But they were not made
Will be
party.
examined by the court on an appropriate date, and if found that the same does not subscribe to the mandate of the statute of persons with the rights of persons with disability, the appropriate orders will be passed by this court. List after returnable date.
No, the petitioners were serving as Anganwadi workers, but she could find the appointment letters. But she could have page 33 for a moment. Page 33, my lord. One of the appointment letters. This is my lord to petition number 1. You are hereby informed that you are directed to render the voluntary service of Anganwadi worker at number 83, Patwari, Anganwadi Center. This order shall remain in force until further orders. You will be paid a monthly honorarium so and so. It is provided that you have to appear once in the interview to be held in the office. Now, this was in the year 2011, Lordship. Thereafter, my lord, when they proceeded with an interview process, which Lordship would find at starts at page 46. In the year 2012, they proposed an interview process. And in that advertisement, my lord, I had approached this honorable court seeking some preference for the service already rendered. Lordship will find the advertisement at page 46. The
Already rendered as?
My lord?
You're already rendered as what?
My lord, I rendered service as the Anganwadi worker, my lord. And thereafter, when I approached this honorable court, Lordship would find at page 56, an order was passed on my writ petition, which at page 57, Lordship will find Mr. So-and-so understanding counsel for social welfare submits that the writ petition is premature and that the petitioner cannot get a case considered in isolation. He also submits that the selection having been conducted, appointment will have to be made on the basis of the results thereof. In view of the above, writ petition is disposed of, providing that the selection will be conducted on the basis of the procedure and guidelines holding the field. Now, from then on, my lord, they have not appointed anybody. My instructions are that the election proceedings were not concluded and I was allowed to continue to serve. Now, my lord, my difficulty arises at page 58, where, my lord, the respondent authority says that I will be entitled to the payment of the honorarium, which was not paid illegally to me. Lordship will have page 58 for a moment. This is, my lord, from the Director, Women and Child Development, Assam, to the Child Development Project Officer. With reference to the subject cited above, I am to inform you that as per your letters mentioned under reference, number 1 and 2, Srimati so-and-so and Srimati so-and-so were engaged on temporary basis as AWW at number so-and-so and 206 Jonia 1 ACWS, respectively, but monthly honorariums were not paid to them with effect from March 2016. It is reported they have been performing all activities of Anganwadi worker till date in the above mentioned AWCs. Further, as per your letter under reference number 3, the monthly honorarium of the above mentioned 2 AWs were not released as per verbal order of the then program officer. As there was no valid cause found behind not providing honorarium to the aforesaid 2 numbers of AWW, you are asked to provide the area honorarium to the said AWWs with effect from March 16 to till date after observing official formalities. Now, the difficulty starts. Moreover, it is to be mentioned that the AWWs have been engaged on temporary basis as per decision of the managing committee, not as per government guidelines. Now, I had referred to the appointment letter, which specifically was issued by the Child Development Project Officer. If Lordship would kindly turn back, my lord.
Get instructions here.
My only apprehension is that they would try to oust me from service without following the due process of law.
We'll see. Let them get their instructions. There's too many facts involved which are not clear.
The only thing is that they agree that I should be paid for my service rendered to till date. If Lordship will find that letter of 25th of January. But they say I'm engaged by the managing committee and therefore they should. That part is what is now troubling me. If they go for a fresh selection, my prayer is that in the petition, if they go for the selection conducted, appoint someone or me or whoever, there is no difficulty. But the introduction of the new factor, my lord, that managing committee nomination, that is creating a difficulty. They want to twist the whole story now.
Yes, what do you say, madam?
Only that part. Page 50 at the last part. Decision of the managing committee. That is not a correct fact. Otherwise, they agree to the
No, where is that order of appointment?
My lord, yes. Lordship will find at page 28 is one.
20?
Page 28, my lord. Annexure 3. It is hereby informed that you have been nominated for rendering voluntary service of Anganwadi worker in so-and-so center for 3 months. If you are interested in rendering the voluntary service, then you are requested to inform the undersigned in writing within 3 days and you will be regarded as joined in the voluntary service on date of receipt of such information. Lordship will find this is an order by the office of the CDPO. It is not by the managing committee. Then this is followed by my joining letter at page 31, And at page 33, the CDPO extends it until further orders. Now they bring in a factor of the managing committee. There was no such thing as a managing committee at that point of time to have appointed me. It was the CDPO who appointed me. CDPO extends my appointment. They admit that they need to pay my salaries. They direct that my salary should be, my honorarium should be released to me immediately.
So why are you apprehending that you will be replaced?
The last portion or the last paragraph
of
page 58, where they admit all the above, yet they go to say the last paragraph, page 58. Moreover, it is to be mentioned that the above AWWs have been engaged on temporary basis as per decision of managing committee, not as per government guidelines. The CDPO engages me. Now they say that it is by the managing committee, not as per government guidelines. So they are trying to give that new angle to the. It is a temporary engagement. We are not on that. But bringing that new angle is what is making me apprehensive that they will try to do something to my service.
At this stage, what interim orders?
Let them not disturb my services without following due process of law.
That goes without saying.
But that is what they try.
That goes without saying. Without due process of law.
Once they say you need not come from tomorrow.
And admitted lordship, this is a temporary appointment.
We are not on
It
that.
is their
They
statement,
can
lordship.
disengage me,
Heard
but
learned
not on the
counsel
ground
for
that I am
parties.
appointed
This
by the managing
petition
committee.
is filed by the petitioner, praying for direction to release the honorariums and other dues payable to her in her payable to her as she's rendering her services as Anganwadi worker in number 83, Bhatna Paiti Char AWC. You are working where, in one or two?
My lord, we are working, we are two petitioners, my lord,
Two
different places. Petitioner one is working where?
In Bhatna Paiti.
Petitioner one is working as Bhatna Paiti Chor AWC. Number 83 Bhatna Paiti Chor AWC. And petitioner number 2 is working as Anganwadi worker in
206 Jonia 1.
206 Jonia-1 AWC in the district under the Mondia ICDS project in Borpeta district. The grievance of the petitioner are that their dues were not released. However, now the department is in the process of releasing the dues, but by communication dated 25th of January 2023, wherein they admit that dues are required to be released, it is also mentioned that the Anganwadi workers were engaged on temporary basis as per decision of the managing committee and not as per government guidelines. Stop. Learned counsel for the petitioner submits that the petitioners apprehend that in view of this statement made in this letter, they apprehend that they may be disengaged without following the due process of law. There MS M. Bhattacharya, learned government advocate, additional government advocate, submits that all Anganwadi workers are temporary workers, and if they are not engaged as per law, then there should be no restraint on the government to release them. Stop. Having heard learned counsel for parties, let it notice be issued returnable 4 weeks. Since MS Bhattacharya
Respondents, lordship.
for all respondents, notices are waived, extra copies be furnished. It is submitted that What effective interim order is necessary here? We can't
No, Lordship.
see any interim order. You are working. If you're not working, then you're not working. Issuance of interim order will create problems. This is not a termination letter or disengagement letter. This is just a passing
We are
reference.
admitting, Lordship, they are working,
So,
Lordship.
Anything, any issues, you can always come back in a fresh case. Prayer for interim, if any, will be considered after the returnable date. Casual interim orders should not be granted. Yes.
Wait, please. Well, upon date of the father of the petitioner, he submitted an application for appointment.
What is this that you are abandoned by your mother, government mother? On what basis are you saying it?
Well, they have filed a case, my again.
Where?
Page 22, pending before the family.
20?
Page 22.
22.
Yes. And that about the OM also does not say, my lord, about the.
What is the status of this case? What orders have been passed?
Notice has been issued, my.
Huh?
Notice has been issued.
Only notice.
My lord. They rejected my application, my lord, on the.
So unless there is some order, how can the authority hold that? How can the authority take into account the financial standing?
Lordship.
My lord, my prayer for compensation ground of the rejected on the ground of para 6 of the OM dated 1/6/2015. Kindly have a look my page 37. It does not say about that, man.
Yes.
Firstly, lordship, kindly look, my lord, the page 35. Last portion of remarks column remarks, 17th column. Page 35. Application is rejected. Murder is a government employee as per the principle of 6 of the OM dated number 1/6/2015. Now, lordship, kindly have a look to the, my lord, clause 6.
Rejected as a mother is a government employee.
My lord, clause 6 does not say so, my lord. Page 37. Clause 6 of the, my lord, OM dated. Page 37.
Clause 6 may not say it, but this is a compassionate appointment. This is not a regular source of appointment. Regular process for appointment. Yes, Mr. Goswami, what do you say?
Lordship, the page 35 is the remark for rejection, Lordship. Page 35, it is categorically stated that her mother
See,
is a
clause
government
9,
employee.
clause 9, page 38, clause 9.
My lord, the monthly
monthly
This
income of the
financial
family.
require
And now,
financial condition.
My lord.
If your mother is a government servant, unless you say you have filed a case, but there's no order has been passed here.
I can produce my lord order.
You produce.
apart from that, Lordship, I would like to submit. After rejection by the DLC, Lordship, regarding as per the remarks in page 35, Lordship, to create a new cause of action, Lordship. This case was filed before the family court, Lordship, on 28/09/2022, Lordship. It is after rejection of the DLC, Lordship. Therefore, Lordship, this case was filed that to create a new cause of action.
You produce that order.
Yes, page number 22, Lordship.
Let him produce that order. We'll see.
Page 22.
What is there in 22?
Yes, page 22 is the petition. It is categorically status filed on 28/09/2022 after rejection, Lordship.
It is not
But
denying.
how? No, but how she was? Why she was not filed any complaint, any maintenance petition before that, Lordship? From her father was dead on 2017, Lordship. And to create a new cause of action, Lordship, this case was filed, Lordship.
Let him produce the order. We'll see on that day. Mr. P.J. Saikia, learned counsel for the petitioner, submits that orders passed by the family court in this matter will be produced on the next date. list accordingly on
2 weeks.
after 2 weeks. Mr. Swami appears for the respondents.
May I please your lordship? Lordship, PK Munu is suffering from high fever, my lord. Matter may be come up on Tuesday, my lord.
My lord, I am not here on Tuesday. I will not be here on Tuesday, my lord. And here is a disciplinary proceeding, my lord, where they may take action on the inquiry report where I am seeking an interim relief. What has happened is the only issue is when they issued me the charge sheet and called me for the inquiry, the witness has been converted into a presenting officer. Number one.
What is the finding of the inquiry report, or
Lordship will kindly have the inquiry report.
is there any
Finding of
notice issued after receipt of inquiry, acceptance of the inquiry report?
My lord, this inquiry report has been given to me asking me to give my reply to the inquiry report. Now,
Are you
why I am before this honorable court is this. The inquiry officer has given a statement that the presenting officer is
No, all right. Your inquiry report is here.
Yes.
You have to submit reply.
My lord, that would not suffice anything because the inquiry report itself was one.
Is there no appellate forum?
My lord, at this stage, the appellate forum would be, my lord, the government. But at this
Exactly.
stage, if lordship will
But it
kindly-
is there. If it is there, it is there.
But lordship will just appreciate two aspects, my lord.
Hmm.
Just lordship will ask for the records if this inquiry report can be sustained.
But
even on the
we would
procedural-
not like to stay the inquiry proceeding.
I'm not on the stay of the inquiry proceedings my lord, at all. If they can show the records to this honorable court to just show that the presenting officer is not the witness in the inquiry and I was given an opportunity of cross-examination, it will end there. If
So
I have not been
he
given-
says Tuesday or Wednesday, whichever day.
My lord, Tuesday and Wednesday, my lord, I'm not here till the 9th. I would be out of station.
It can't be helped. Then on 10, what date is 10, 11,
Let it be on the 11th. my lord.
11.
Any day convenient. I'm just not here from the 4th to the 9th. I'm not here.
16th. 16th?
Till then, they will not act on the inquiry report. That is all I'm saying. Not act on the inquiry report. My lord. Let them place it
Before
the
acting, they'll have to put you to notice.
My lord.
Before acting,
My lord.
they'll have to put you to notice for imposition of penalty.
My lord, the inquiry report has been given to me. Today is the last day for filing the reply to the inquiry report. My lord, when I have not been given an opportunity of cross-examination.
Now, on what basis do we ask them not to proceed on the inquiry?
Because, my lord, they have not given me an opportunity
That will
of
require
cross-examination.
examination.
My lord.
That will require examination.
But then by that time, if they, my lord, do anything on the...
If they do, they do. You will have to come back again.
I lose my job, my lord. I have served from 87.
No, that is what I'm asking. What is the punishment proposed to be imposed?
The termination of service.
Where do you find it?
My lord, that is rule 7, my lord, lordship will find.
What is the recommendation of the inquiry officer?
Inquiry officer, my lord, at page 45. At page 45, my lord, the last paragraph. Hence, the authority may take a decision to impose any of the punishment on Sri so-and-so as per Rule 7 of the Assam so-and-so for the offences done by her as stated above. They want to say that the SEBA says that they do not have a record of my passing the matriculation examination. That I have given at page 46. They did not even ask me to produce the data. Lordship will find, if Lordship will kindly have page 44 for a moment, page 44, my lord. At the top, Lordship will find, I was appointed as inquiry officer while letter number so-and-so to cause an inquiry into the allegation against Kalpana Majumdar. Srimati Swapnarani Deka was made the presenting officer. This itself is wrong. If Lordship will kindly have page 29 for...
We are not examining it. Why are you trying to insist? Where is the finding that you have to be terminated?
My lord, at page 45.
Impose punishment under
lord,
Rule 7.
Rule 7, my lord.
Then is termination the only punishment?
My lord, there are other punishments also.
Then that stage has not come, Mr. Majumdar. We can't stay disciplinary proceeding just like that without looking into it.
Then Lordship will allow me only one option. If it is being taken up on the 13th, I will not be required to submit my reply to the inquiry report at this stage. Otherwise, they'll foreclose that option. On 13th, if Lordship finds that there is nothing in the case, my Lordship will.
No,
dismiss the
why
petition, I can file-
why that will require some examination in the matter.
But that is there, but
Then
the last date is to file the replies today.
let
If
the
I'm
counsel
before
appear, let us hear what he has to say.
then Lordship has it on the 3rd.
13th, all right, 13th, list on 13th.
So
13th,
much of
3rd, my lord, I was praying today after the
third. Third is not possible.
I'm praying for my lord. I'm praying for an interim on the basis of the records.
We can have it on 4th.
4th, I'm not sure. Then let it be 13th. This
4th or can have it on 6th also.
4th to 9th, I'm not sure. That is the. Let it be on 13th.
It is submitted by the learned counsel for the respondent, Mr.
A Gayan on behalf of PK Munir.
A. Gayon, who appears on behalf of Mr. P.K. Munir, the standing counsel for Khadi Board,
Khadi.
that Mr. Munir is indisposed. Stop. Mr. Mazumdar, learned counsel for the petitioner, submits that the petitioner is apprehensive of the fact that the departmental proceeding which has been initiated, inquiry has been completed, matter is at the stage of acceptance of the inquiry report by the inquiry officer, by the disciplinary authority. Stop. It is submitted that there is a strong apprehension that major penalties will be imposed, including termination from service, and therefore the writ petition has been filed. It is submitted that the inquiry proceedings conducted is totally contrary to the provisions of law, and no opportunity of cross-examination of the witnesses was offered to the petitioner. Stop. Since the matter stands deferred today, let the matter be listed again on 13th. Meanwhile, the department will not proceed to take any coercive action against the writ petitioner till 13th. Till 13th.
My lord, matter may be hard on 13.
That's what we propose to do. That is what we'll do on 13th. Meanwhile, till 13, don't take any coercive action against the petition.
My lord may not pass any such order.
Why? Or we record your submission that you undertake, department will not proceed. We'll record it. It's only a undertaking not to give a coercive action. That's all. We are not passing any interim order or preventing you from taking any steps or interfering with the inquiry proceedings. All right. List on 13.
Much obligation.
The petitioners are the Anganwadi worker, your lordship. In 2020, Ministry of Home Resource and Development, my lord, Human Resource and Development initiated a national educational policy, my lord. In that policy, your lordship, there is a provision for Anganwadi worker for 6 months training course, your lordship, for 10+2, who have qualification of 10+2. And accordingly, in Bhattacharya ICDS project area, my lord, that policy is for the first time implemented this year, my lord. And in that process, all the Anganwadi workers who have the qualification of 10+2 are directed to submit their education and testimonial. And thereafter, my lord, what happened? A list has been prepared by the director. And in the state list, my lord, the name of the petitioners are there who are eligible for participating in the training course. But what happened on the eve of the training, my lord, the CDPO, without any written order, my lord,
told the petitioners that they are not allowed to participate in the training process. When the petitioner asked why, then he said that you have a higher secondary pass qualification from Assam State Open School, which is a school of, my lord.
Where is the training going to be held?
Training is already started on 26th, my lord, of this month, my lord.
But then on verbal order, how do we,
My lord,
where is that application that the CDPO asked you not to attend verbally?
my lord,
Have you approached before the competent authorities?
because on the 26th, my lord, in the eve, on the eve of the training, my lord, we are at an immediate we had approached before this honorable court.
No, before this court, how does this court find out on what basis? Yes,
Instruction may be called for. My
yes, call for instructions.
Allowed to participate, which shall be the outcome of the writ
No, we
petition.
can't give you orders. We don't know why you did not participate. You are saying you're making a statement, the CDPO prevented you
My lord,
orally,
orally.
verbally. Then why should we?
We are not allowed, my lord. So, my lord, my humble
Yes.
My lord, I am appearing for respondent number 6 only, my lord, the Assam Higher Secondary Education.
Oh, sorry. Who's for the Women and Child Development Department?
But here it is written, Lordship, social justice and empowerment, where they have their separate standing council, Lordship.
The
Women and
standing
child
councils are
lordship
not
we
there. We
appear.
can't help it. Have you served copies?
Yes, see, well,
Have you served copies?
we are all social justice and empowerment department, Lordship.
This is a black case, right? This is a,
What?
Abida.
এটা আবিদা ভাগদারি okay.
I'm a senior politician and another. Training is for in a week, my lord, 3 days training is provided, my lord. Monday, Wednesday, 4 days, Butterfly ICDC project area. In a week, my lord, training is provided in 3 days for the Butterfly ICDC project area, my lord, and it is Monday, Tuesday, and Wednesday, my lord. And that it is
Yes, madam, you get instructions and
Lordship, kindly fix on the next week, Lordship. In the meantime, I shall append instructions.
Wednesday.
Lordship,
my lord,
Wednesday or Thursday, Lordship. Because Monday is a holiday, that's why I'm telling.
in the meantime, maybe we may be allowed to participate. That shall be outcome of the writ petition, my lord.
No.
No, Lordship.
We
I
want
shall
to get
place
instructions
instructions.
of why you are not allowed.
Yes, Lordship.
Why maybe you did not go on your own.
Yes, Lordship.
Because there should be, because my name is enlisted by the director, my lord. If our name will be cancelled, then
No,
there should be-
how has it prevented you physically?
My lord, yes, they apprised me that
No. How has the ICDS, what is that? CDPO. How has it prevented you physically?
He told us that you are not allowed to go.
That is not sufficient.
From Monday again it is started, my lord. In
Monday is a holiday.
Monday.
No, then it is Tuesday it is started, my lord, because last because it started from the Monday. But
You
because of the
attend
holiday,
later,
the
you'll attend special training if required. We'll direct.
my lord.
Let it be on Wednesday, get your instructions
Lordship,
on Wednesday, why the
Yes, sir.
CDPO is
Yes,
prevented.
Lordship. I shall.
Let the matter be listed again on Wednesday, which is 4th, on which date MSM Bhattacharya, learned additional senior government advocate, will obtain instructions as to the contentions raised by the counsel for the petitioner, that although the petitioners were selected for appointment for undergoing a training. In what is the training?
District level 6-month training course, my lord.
District level
6-month training course.
6-month training course. But
Page number
the
32.
CDPO, concerned CDPO, allegedly prevented the petitioner not to attend. Concerned CDPO purportedly did not allow the petitioners to participate in the training program. Instructions to that effect be placed before the court on the next date fixed.
Lordship, let them give extra
Copies be furnished to the learned government advocate
Today.
during the course of the day.
Yes. Deeply
Least on 4th.
Wednesday, my lord.
Wednesday is 4th. 4th.
All right.
May I please, Lordship?
Yes.
Lordship, this case, Lordship, matter related to the selection of the constable GD in Central Armed Police Force, Your Lordship. That the petitioner has secured more marks than the unreserved candidate, Lordship. Petitioner belongs to SC category, Lordship. So, Lordship, kindly come to the page 63, Lordship. That the petitioner has scored 45.44, page 63, annexation 9, Lordship.
60?
3, Lordship. 63, annexation 9, Lordship.
Yes.
That the petitioner has scored 45 below, Lordship, 45.4425, Lordship. Marks, Lordship.
What is 63? Revised marks.
Yes, Lordship.
Ah.
But as the cut-off marks of the testimonial authorities in Assam category, Lordship, come to the page 62, Lordship.
What is 64?
Yeah, 62, Lordship. 62.
62. Yes.
Some of the candidate Lordship, unreserved Lordship, they got the appointment, Lordship. Those who get less mark than the petitioner, Lordship. So
We'll see. Okay, hard learned counsel for the parties issue notice returnable 4 weeks. MS so appears for the respondents.
Lordship, similar another matter is pending before this Lordship. Kindly list along with the petition number 5377
It is submitted. The writ petition be listed along with 5377 of
2023.
2023. Since learned counsel MS so appears for the respondents, notices of waivers, extra copies be furnished.
Most of them.
One of the petitioner from a lord is a junior engineer in the Directorate of Agriculture, aspiring for promotion to the post of assistant engineer. Malad, there is a criminal case pending against him, for which he was arrested, placed under suspension. Thereafter, prosecution sanction was given. Correspondingly, concurrently, a departmental proceeding was drawn on the same charge. The departmental proceeding after inquiry, well, he was exonerated. All those charges were found to be unfounded because Malad, the money was already received by the supplier. So there is no misappropriation of money, common money. Thereafter, Malad, similarly, this is a case wherein Malad, all over the state, in each district, the anti-corruption vigilance department had, Malad, made the cases. Case number 56 of CIDP PS case number 56 of 14. Now, in the case of the petitioner, Nagaon, there is a part charge sheet filed. In Nalbari also, there is a part charge sheet filed. But in both the cases, Malad, department proceedings have resulted in exoneration. Now, what happened, Malad? There was a DPC considered, if Malad can have page 43, Malad. My lord, this is on recommendation of the Department Promotion Committee in its meeting held on 28/8/23. My lord, serial number 1 is senior to me.
Yes.
Whereas, my lord, serial number 2 and 3 are juniors to me. They have been promoted as assistant agriculture engineer. Whereas, my lord, I have been not promoted because, my lord, they say my criminal case is pending. But, my lord, similarly situated, same department, same.
Do you have a copy of the DPC minutes available?
No, my lord.
Your case was obviously considered.
Considered. They might have kept it in seal
cover.
Lordship. But my case is.
Why seal cover?
Because that prosecution was sanctioned in that case. But my lord would see at page 45.
Yes.
Same accused with me in that same case, arrested, prosecution sanctioned, part charge sheet filed. Last year, my lord, he was promoted. Because in the department proceeding, it came to the conclusion that there is nothing against it. My lord can have that findings. The department proceeding at page 31.
You have DPs of the other person, not for you. Your DPs are not.
My DP, my lord. I'm not
that is what we wanted to see.
My
Page 31.
31, last paragraph. This is a unique case, my lord, wherein, my lord, the DP I am exonerated. Last paragraph. Whereas the inquiry officer and secretary so-and-so submitted the inquiry report on the department proceeding in respect of Rohit Borali, junior engineer, and observed that, as alleged, there was no negligence or nor sincerity on the part of the delinquent officer while implementation of the scheme, and there was no dereliction in his allotted duties. This is corroborated by the evidence of all the 3 prosecution witnesses. The delinquent officer was not found to have violated government procedure. Further, as the dealer supplier had stated to have received the full amount against all 6 power tillers, misappropriation of government money could not be proved against Rohit Bonali, JE Agriculture. Accordingly, my lord,
Yes.
it was dropped. Only there was a caveat made here that in the criminal case, if something happens, if I am convicted or something, they will, my lord, renew this. Otherwise, the finding is, my lord, I am gone. There is nothing against me. And the charges also in the criminal case and the department proceeding are one and the same.
Yes.
The only thing, my lord, I have come up before your lordship is, my lord, he is retiring tomorrow. So, my lord, just made a claim, because if I don't make a claim, I don't make a challenge to that. Maybe, my lord, subsequently they will say, if they have not considered my case, they will not consider my case. I will retire. My lord, only a notice and let them produce that minutes, my lord, on the next day. Of both, my lord,
Why should we
DPC
look
of-
in? Why should we look into the minutes? Let them consider your case. If
No, they
if
have
want to.
considered that. They have considered, my lord. I think they have kept it in seal cover. My lord will only call for 2 minutes, my lord. Page 45.
So why should we call for the minutes?
Because, my lord, the similarly situated person.
How does it affect us? Why should we look into somebody else's minutes?
No, because, my lord, the accused in both the cases, both the petition, both the persons involved are accused in the similar case.
You may be interested. We are not interested to look into the minutes.
I got.
So why should we look
Let
into
them,
this? Let them
my
find
lord,
out.
find
If your case can be considered in terms of the person at page 45,
lordship,
who is similarly situated as you say, then
Lord.
can be considered.
Fine, no.
Heard learned counsel for the parties. This writ petition is filed with the petitioner challenging his non-promotion to the post of
Assistant Agriculture Engineer.
Assistant Agriculture Engineer Headquarters.
There were
Sorry,
4
Assistant Agriculture Engineer. Stop. Petitioner is presently working as a junior engineer in the Agriculture Department. It is submitted that pursuant to a complaint raised, matter was investigated by the investigating agency. He was arrested, subsequently released on bail.
Lordship. Suspended, reinstated,
released on bail. Stop. He was consequently suspended, but and thereafter reinstated. The departmental proceeding was also initiated, but by order dated 19th of August 2019, issued by the competent authority, the petitioner was exonerated of all the charges, and the departmental proceedings were finally closed. Stop. Learned counsel for the petitioner submits that persons junior to him have been considered for promotion. And in fact, another officer who was also similarly situated like the petitioner in respect of the
CID
criminal
PS
proceedings initiated has also been considered for promotion by order dated 15th February 2022. Stop. It is only the petitioner who has not been given effect to as the DPC as the findings of the DPC in respect to the petitioner are being kept in seal cover. Stop. Learned counsel for the petitioner submits that as on date no charge sheet has been filed.
No, part charge sheet has been filed.
Part
in
charge
both the
sheet.
cases.
Not against him.
Against him also. Part charge sheet in both the cases have been filed. Prasanta Saharia also, Nolbari, part charge sheet. This man, Nogam, part charge sheet.
No, then where's the...
Because part charge sheet, it has not gone further. And they have
no,
come
but
to
your
the-
name is there. Whether part charge sheet can be filed, not filed is a different issue.
Fine,
But
but even in case of Prasanta Saharia, because of the department proceeding,
all right, it is submitted that part charge sheet has been filed against the petitioner as well as the another officer, namely Sri Prohanta Kumar Sovaria, who has in the meantime been promoted as assistant agricultural engineer. Stop. Petitioner seeks a direction from this court that his case be taken out of the seal cover and appropriate orders be passed. Mr. Mr. B. Chaudhary, Learned Counsel for the Agriculture Department, submits that you'd like to obtain required instruction. Where accordingly, let notice be issued returnable 4 weeks. Since Mr. Chaudhary appears
For all.
for all the respondents, notices are waived. However, extra copies be furnished within 1 week from today. Matter be listed after the returnable date, and Mr. Chaudhary will apprise the court as to the status of the consideration of the petitioner's case towards his claim for promotion to the next higher post.
With maintaining parity with my lord. That much can be added, maybe it will be done. He's retiring to.
No, he's retiring, he's waiting for so long.
No, wait. The order came only on day after. The order is of month 22/9.
22/9.
Then I got it. I came. It takes some time.
All right. After returnable date, we'll consider interim prayers to be considered after returnable date.
Much obliged.
Mr. Lordship. Lordship, the petition is a candidate for Sub-Selection Commission online application recruitment process of Constable GD, Lordship. But he have qualified in written test, then after physical test, and he was called for medical examination, but he was rejected due to medical examination on the ground that he is medically unfit for cardio, borderline cardiomegaly and ECG abnormal. After that, the petitioner approached the Narayani Hospital before Narayani Hospital, Guwahati, Lordship, and found that his ECG is normal, Lordship, and SR.
Yes,
This appointment was not considered by the respondent authority, Lordship.
Where is the advertisement?
Lordship?
Advertisement.
Advertisement I have not annexed, Lordship.
Oh,
Online portal, Lordship.
heard learned counsel for the parties. This writ petition is filed with the petitioner aggrieved by his non-selection to the post of Constable GD in the Assam, in the Central Armed Police Forces and other allied services. Stop. Petitioner applied for the selection process through the online portal. Stop. The petitioner cleared all
medical unfit.
the what is the process for selection? Written.
First written, then physical, then medical. I have already
Cleared
qualified in
the
physical
written
also.
and physical tests. However, in the medical examination, he was declared to be unfit, and shown to be a borderline case of cardiomegaly within quotes. Learned counsel for the petitioner submits that subsequently he underwent a test in a private hospital and his cardiac condition was found to be normal. Being agreed, he submits that the direction be issued for constitution of a review medical board. Will you institute a review medical board?
Lordship, notice may be issued, Lordship. I have to think.
Lordship, in WPC number 6214/2017.
Yes, we
I
have seen.
annexed.
We have seen.
Review one and
MSB Sharma, learned counsel for the respondent, submits that notice be issued as she'd like to complete her instructions in the matter. Accordingly, notice be issued, returnable 4 weeks. Since the learned counsel appears for all the respondents, notices are waived. However, extra copies be furnished within a period of 1 week from today. Matter be listed after returnable date. Interim prayer, if any, will be considered on the returnable date. Yes.
Lord, we have no objection.
Impleadment
Yes.
of respond or opposite parties, my lord, 1 to 14 is respondents number 11 to 24. They are the promotees. my
Okay,
lord.
heard, disposed, impleadment permitted. What are the names of the parties?
My lord will find at page 7, 8, and 9. These are the opposite parties, my lord. At
They are to
page-
be impleaded.
Yes, my lord, they will be included.
They are to be impleaded.
Yes, yes. Page 7 to 9.
Opposite parties, 1 to
14.
1
to 14.
14.
14.
I don't know how you prepare this. You see, you have to give the names of the parties who you want to implead is separately mentioned in the course title. That was the practice, I think. I'm not sure.
That
What
is
is
it.
it now?
That's the practice.
So
It was always the
Page
practice.
4, 5, 6, my lord.
4, 5, 6, you have added everybody.
Yes,
That is the 4, 5, 6 is the
respondents. my lord.
page number 2 reflects the current respondents, isn't it?
Yes, my lord.
Up to
Up to page number 6.
they are all they are the present respondents.
Yes, my lord. In the name of respondents, my lord, we have incorporated the name of the respondents which are newly included.
I'm asking you whether these are already respondents or you want to implead them.
Some of them are respondents.
Or point out how do we issue an order?
At page 7, 8, 9, lordship will find that. From one
This
to-
is not the way to prepare a application. There is a format. Please look into it.
My lord,
These names should be reflected separately.
my lord.
It is submitted that respondents 1 to 14. 1 to 14
Yes, my lord.
are to be arrayed as respondents.
Respondents from 11 to 24.
Number 11 to 24 in WPC 1530. Stop. Mr. P.K. Tiwari, Learner Senior Counsel, assisted by Mr. So-and-so, does not object to the prayers made. Accordingly, prayer allowed. Petitioner is permitted to array so-and-so respondents as respondent number so-and-so in WPC 1530. An amended course title be filed
Right.
in the registry within 2 weeks from today. Stop. I accordingly stands disposed of. In the writ petition, you write, in view of the order passed on so-and-so, respondent number so-and-so are permitted to be arrayed as respondents so-and-so to so-and-so.
11 to 24.
11 to
24.
24. The petitioner is also required to file the amended course title within 2 weeks as directed.
And Lord, notices may also be issued to these private respondents.
Let them come here first.
All right. Yes, that's it. All right.
He has to file a
Yes, yes.
amended,
all right.
then it has to come
Yes,
here.
yes.
Only then matter be listed after 2 weeks. Pursuant to filing of the amended course title as directed.
Lordship, on last occasion, Lordship has confronted. Arre, ki kore? Your phone. Lordship, the original records are held by the then CDPO Lordship. So original records are not there, Lordship. And he has been asked to hand over. It is much before the Lordship taken the matter, Lordship. And now the departmental proceedings has been drawn against the particular CDPO Lordship for not handing over the original records of the, not only
So,
these cases, but
what is this instruction? Longish in the instruction. What is this?
Lordship, their instruction, if your Lordship may kindly, instruction page 2, Lordship, is the matter of 2009 Lordship, as the records are not available of that period, Lordship. Since 2013 Lordship, different committees has been formed and survey has been done, Lordship. And this goes in favor of the private respondent number 6, Lordship. I have submitted the documents, whatever is been available from the office.
You bring it on record.
Lordship, actually.
MS M. Bhattacharya, learned government advocate, submits that the instructions have been received. And as per the inquiry conducted.
Actually, on 16/11/21, they filed a affidavit in opposition.
No, this has come now.
No.
Inquiry conducted, and the reports, it is reflected that the private respondent is.
Her name is included in the survey register as serial
Her
number
name appears
43,
in the
Lordship.
survey register as she is a permanent
And
resident
missing Kathonibari AWC, Lordship.
of serial number 43 under the missing Kathonibari AWC. Stop. The relevant documents are enclosed with the instructions received. It is the government advocate is permitted to bring these facts on record by filing necessary affidavit.
Lordship, I shall.
Accordingly, matter stands adjourned for 3 weeks. Mr. S.K. Chakraborty appeals for the petitioner. We are giving you back the
And Lordship, I shall take back the.
take back the
Lordship.
records. Yes.
Deeply obliged, sir.
Lordship,
Huh? Yes.
Lordship, DSGI is appearing in this case. Lordship, he is in another court. So matter may kindly be taken up after some time, Lordship.
All right. Let it be next week then.
Then can it be on 10th, Lordship?
10th.
Wednesday, my lord, already it was fixed for some instruction. My
All right. Then second half. All right. Second half at 2. At 2. At 2 p.m.
In this matter, the petitioners are claiming the benefits of minimum package being granted in the open the case, your lordship, and they are squarely covered. In fact, in the earlier round of litigations also, there are judgments in their favor, and then the government in the review petition, they filed a review petition challenging the order, but subsequently the government withdrew the review, saying that their case will be considered under as per independent order. Thereafter, your lordship, I'll take your lordship.
Before he starts, Lordship, I've been requested by my brother, Lordship, Mr. Devnath. I've been requested by my brother, Mr. Devnath, who is appearing for P&A department, to take up the matter after some time, Lordship, because he's on lake in some other court. If possible.
In the meantime, I may submit the facts, your lordship.
What is your prayer here?
To grant the benefits, your lordship.
Minimum pay scale.
Minimum pay scale is given.
You had come earlier before this court.
Earlier, when this minimum pay scale was not granted, initially the government granted some fixed pay. So we were denied. Then we approached the honorable court. The court said that that should be considered. When this order was in court, in the meantime, open the judgment came. So they said that since open the judgment is there, that partners who were serving for last 10 years, they will be considered. So our case will be considered under the open that. And accordingly, your
yes.
And accordingly, your lordship, a direction was given. Lordship will kindly see page number 59.
Yes.
This is a letter by the finance department to the commissioner of all departments. That page 59, lordship has got it. Finance department to the commissioner, with reference to the above, I am directed to state that pursuant to the honorable.
Your names were not sent.
Our names are also sent, your lordship.
Then
your lordship, the impugned order was passed at page number 66 by the finance department. Lordship, may I read? The following are hereby notified for compliance by all state government departments as applicable for master role workers, casual and similarly placed employees who were appointed prior to FRPM period, that is 1st September 2005. So for the first time, they have come with a notification saying that the casual workers who were appointed prior to 1st September 2005, they will get the benefits, your lordship. And I am appointed on 31/12/2005 and 15/12/2005. Lordship has got it. Thereafter, your lordship, we have approached this honorable court. In the meantime, your lordship, this distinction has already been done, and post FRPM candidates have also been given the benefits, which I have brought on record by way of additional affidavit.
And many persons have got that because of the pendency of the case, who have not been considered. But candidates of post FRPM, that is, who were appointed after of the 1st September 2005, they have also got the benefits, Your Lordship. So when we came, Your Lordship, at that time, this notification was issued saying that those candidates who were appointed prior to FRPM period, that is 1st September 2005, they will get. Since we were after since our appointment was subsequent to 1st September 2005, so we approached this honorable court. But subsequently, Your Lordship, even candidates of post FRPM period, they have also been granted the benefits.
No, where is the denial in page 66?
No, Lordship, may I read, Your Lordship?
Huh.
The following are hereby notified for compliance by all state government departments as applicable for the master role, workers, casual and similarly placed employees who were appointed prior to FRPM period, that is 1st September 2005. So those employees who were appointed prior to 1st September 2005, they are to get these benefits.
And what is the judgment of the
Upendra?
report?
Yes, Lordship. Lordship will find it at page number 53, relevant paragraph. At that time, there was no mentioning of any FRPM period or anything like this. At page 53, Your Lordship. It starts from earlier, but page 53 is the penultimate paragraph.
Yeah, who is for the finance? Finance.
In fact, finance has already submitted a
The Lordship, my Lordship, Mr. R. Borpujari appears for this matter, Your Lordship. Today, due to personal difficulty, he could not be present, Your Lordship.
He could not be present. There are other standing councils. We can't keep on adjourning matters like that. We only want a specific instruction as to this page 66 in the writ petition. I am sure you don't have a copy of the writ petition.
I have, Your Lordship.
You have. Wonderful. Page 66.
Finance has already filed an affidavit.
Page 66, there is a, have you found it?
Yes, Your Lordship.
This is 8th of March 2019. Is that the date?
Yes, sir. Yes, Your Lordship. 8th of March 2019.
So you are withholding the benefits to persons who were appointed prior to 1st of September 2005.
Yes, Your Lordship.
No, you are granting benefits to first people appointed prior to 1st of September 2005. But in the directions contained in Writ Appeal 45, no such category has been specified.
Only I think, Your Lordship, they have considered this, and
When were you appointed?
he was appointed on 31/12/2005 and 2 persons, and another on 15/12/2005. People kindly take up the additional affidavit. Subsequently, this notification was issued, and we have found that post FRPM period they have already granted the benefit. Lordship, page number 91, the additional affidavit starts, and I'll take your Lordship to page number 95. So now this distinction is no more there, Your Lordship. So it may be disputed. Lordship has got page 95. 93 is the type copy. In pursuance of Finance Department letter number so and so, along with the
You consider their cases. When is Mr. Borpujari coming?
Your Lordship, today he is not present today, Lordship.
Take your Lordship to page
Is
number
there
97
tomorrow?
for a moment, because this distinction is not in existence. Page
Who
97.
else appears for the finance?
Let them consider it and in a time frame manner.
All right, we are posting it on 4th. You ask Mr. Borpujari to appear on 4th. list on 4th as it is submitted that the council, standing council for finance is indisposed. Mr. So-and-so appears for the petitioner and learned counsels appear for the respondent.
And endeavor will be made to dispose of the matter on that day.
We'll dispose it of. They ask him to appear on 4th.
Okay.
Yes.
Obliged.
In fact, on the last occasion, the Panchayat department was asked to take it that night.
You produce it on 4th. Yes.
Discuss, my lord, regarding my lord, absorption of the my lord, additional Mondal to the post of land Mondal, my lord, under the establishment of the deputy commissioner. My lord, what happened, my lord, these petitioners were appointed way back in the year, my lord, 92, 94, and 98, my lord. As additional Mondal under the establishment, amalgamated establishment of the respondent number 8, my lord, that is settlement officer, Bhubi and Kokrazar, my lord. Thereafter, my lord, they have been working in the said capacity till that, my lord. But their service has not been absorbed as Lat Mondal under the establishment of the deputy commissioner Kokrazar, my lord. Or, my lord, some similarly situated persons, my lord, they got regularized their service in that year, my lord, 2013, my lord. My lord, I have annexed, my lord, order of this Honorable High Court, my lord, Annexure 6, my lord, page 34. These petitioners, my lord, are the similar, my lord, who are also, my lord, working as additional Mondal under the.
What is the stand of the government?
My lord, government, my lord, the stand of the government is, my lord, they filed, my lord, additional affidavit, my lord, that 20 out of 28 additional Mondals, my lord, already 20 additional Mondals have got regularized their service, my lord, but these petitioners' service have not been, my lord, regularized.
Yes, Mr. Indik.
Lordship, my lord, my lord, this petitioner was appointed under the my lord, the BTC area. Lord, that's why, my lord, we have said it in our affidavit.
Then
Anyway,
who is to look into their?
My lord, the BTA.
Yes, BTC.
Lordship, we have already cleared our 10, Lordship, because these additional Lat Mondals were appointed before creation of BTC, Lordship. And now, Lordship, State of Assam has took policy decision and they have appointed their which fall under non-BTC area, Lordship. But in our BTC, they are clearly stated that as there is many local people who have passed 6 months recorders training certificate course for Lat Mondal, Lordship, we will go by press advertisement and press appointment, Lordship. We cannot absorb which were earlier appointed by the State of Assam, Lordship. Our instruction already placed by the
BTC is not a state.
No, Lordship, it is transfer something, Lordship.
So, will you not consider the services of other
No,
employees?
Lordship, these are our other people also past training, Lordship.
Maybe.
They may appoint by the State of Assam in other places of BTC area.
We are also, my lord, belongs to the BTC area, my lord. And also, my lord, we have been appointed in the BTC area, my lord. And now, my lord, they are denying to regularize, my lord, our service. I have also filed additional affidavit, my lord, regarding this instruction, my lord. We got our training, my lord.
They were appointed in the year 92, 94, and 98 by the State of Assam for resettlement operation in Dhubri, Lordship.
Dhubri and Kokrazar.
Dhubri and Kokrazar, Lordship.
Yes.
But
This amalgamated establishment of the settlement of
Yes, revenue, you have to take a decision on this.
My lord, in our affidavit, we have stated, my lord, that for regarding my lord regularization, Lordship, may kindly see the annexure to page 120.
You please bring this on record.
It is in record.
No, this letter.
this law, though I have not filed affidavit by place before the
No, please bring it on record.
Lordship, Lordship.
Yes. No, your affidavit, what have you stated?
additional affidavit, Lordship, it is stated that, my lord, those who are working in the, my lord, that additional Mondal, Lordship, if their service have to be regular, but they have to appear before the, my lord, the interview. When the advertisement is made, Lordship, but some weightage has been given, and as per the seniority, they will given the, my lord, that preference. Lordship, may kindly say to 127 in the page.
Okay,
Lordship.
we'll take it up in the second half. Yes, second half.
Yes, sir.
Where is the decision taken by BTC?
Lordship.
BTC has taken a decision
Lordship.
that they shall not be appointed in BTC area.
Lordship, in my
Absorption is not possible. That is saying.
Huh?
Not possible in BTC. They are not saying Lordship.
Mm.
Absorption is not.
Absorption.
Yes, sir.
absorption, my lord, for my lord, they have to appear in the, my lord, that selection process, Lordship. Lord, in my affidavit, Lordship, the file, Lordship, the additional affidavit file, Lordship, on file on 14 September, Lord. File on 27/7, Lord, or 29/9.
Next year. It will be.
Sorry, Lord, 14/9, Lord, because file on 14/9.
Additional affidavit.
Lordship, in a paragraph number 5, Lordship, I have stated in page number 124.
Yes. Yes.
Lordship, that the department back to state that the absorptions of additional Mondal engaged in the settlement operation or resettlement operation shall be guided in terms of the Gov Office Memorandum by number so and so dated, my lord, 23/9/2013. Is annexed as Annexure 2, Lordship, page 125. Lordship, be it stated where the vacancy of the Mondal or Patwari arises in districts, the district commissioner oblique the appointing authority will call for the application to fill up the same as per existing rules and procedure. Due weightage and preference shall be given by the selection committee to the additional Mondal or Patwari, depending upon the length of service rendered by him or her. And even in Lordship, the relaxation of age also is there, Lordship.
So they were not allowed to appear. That is their.
No, that is not. He have to apply for the proportional.
Our absorption process is not, my lord, taken till that, my lord. My lord, kindly see, my lord.
It is their case that this.
The absorption, how can my lord have when the advertisement is my lord advertised was my lord given, Lordship, then my lord they have to apply for proportional.
Advertisement for what?
For the appointment of the Mondal, Lordship.
They are already appointed.
Yes,
they are appointed only for the limited period. For the settlement operation or resettlement operation. This is for a particular period, Lordship.
Where is your appointment order?
My lord, Annexure 1, 2, and 3, my lord, can you see? Annexure 1, my lord, that is. Annexure 1, my lord. It's my lord.
Additional Mondal.
Petitioner number 1. Yes, my lord. Percentage selection process, my lord.
This appears to be a regular appointment.
Lordship, my lord, that every my lord the appointment is made
for a period of 3 years.
Selection,
Hmm?
after due selections, every Mondal has been, my lord, this settlement operation or resettlement operation has been appointed by this.
Till that, my lord, on the basis of this appointment, my lord, till that,
And that this
continuation, my lord.
And this, my lord, that their services to till, my lord, that when the settlement operation is operated. After the completion of settlement operation, they are not in a service. Lord.
Now, when is the advertisement? When was it issued, or when is it likely to be issued? Notification.
Notified recently, my lord, that Bangladesh districts last 2-3 months before, Lordship, it has been advertised.
Was it issued in BTAD areas?
No, he cannot, my lord, he cannot claim that I can be absorbed in the material area. He can apply, my lord, in non-material area also. But he have to, my lord, apply through the proportional, lord.
My lord, there is a, my lord, guideline, my
Where is that?
lord, that is, my lord, kind of is, my lord, 33, my lord. There, my lord, additional members, my lord, kindly come to my lord.
This is, lordship, my lord, incompleted, my lord.
Page number?
Page number, my lord, 33.
Incomplete or document.
My lord, on the basis of these, my lord,
These
guideline, my
documents
lord,
I have annexed in the, my lord, that mean my additional affidavit in page 127, lord.
127. This is different. 127 is different.
Can you see the last context of this, my lord, that absorption of the Mondal, lord. This is the view, lordship, which my learned friend has been annexed it. Lordship, may kindly see in compliance of the aforesaid order dated order of the Honorable High Court and taking into consideration the relevant factors include the views tendered by the legal members and the learned Advocate General of Assam. The matter is this policy has been taken. Views this is that. And after that, my lord, this has been, my lord, this notification, my lord, that office memorandum has been, my lord, published.
So what is decided by the office memorandum?
Lordship, man, kindly say 127, lordship.
Clause number 7.
Lordship, my one lordship, my kindly see 127.
Clause 7.
7, lordship, lordship. One also. Whereas the vacancy of the Mondal and Patwari arises in the district, the Deputy Commissioner and Appointing Authority will call for application to fill up the same as per the existing rules and procedure. And lordship, may kindly see the serial number 3, due weightage and the preference shall be given by the selection committee to the additional Mondal and the Patwari upon the length of service rendered by him or her. Next, lordship, the relaxation and condonation of arrears in respect of the additional Mondal Patwari, if necessary, he shall be allowed for as a matter of the policy. This is given, lordship. Everything that they have to given the preference and also over relaxation of the arrears, lordship.
Yes,
But they
Mr.
have to appear, my lord, in the sum of the my lord, that candidate who are, my lord, in Golpara district. Those who are, my lord, working as a, my lord, that
yes.
additional
Kindly see, my
Mondal.
lord, page 33, my lord. My lord, in my petition, my lord.
Yes.
My lord, kindly see, my lord,
It
point
doesn't
number 1, my
contain
lord.
any date,
Thanks
doesn't
to-
give you any indication who has issued it.
That's why, my lord, in last occasion, my lord, it
My
was
lord, on
asked
the-
to appear, my lord, that produce the
On the
original
basis
one.
of this, my lord, guideline, my lord. the
When
honor-
was it issued? Which date?
My lord, date, my lord, 3/5/2012, my lord.
Now you come to the page 127. This is a subsequent office memorandum. It mentions that it supersedes all other office memorandum.
That is true, my lord. My lord, the Honorable High Court, my lord, in the earlier occasion passed, my lord, order who are similarly situated, my lord.
Yes, where is that order?
Yes, my lord, kindly see page, my lord, 34, my lord. Who are also working under the establishment of the respondent number 8, my lord.
Hmm.
We are also, my lord, similar situated person. By this, my lord, in view of this order,
This order was passed
yes, my lord.
earlier.
Yes, my lord.
Now pursuant to that,
This office memorandum has been published.
the office memorandum has come out.
Kindly see last paragraph, my lord. The petitioner therefore deserves to consider for regular absorption as Mondal against the existing vacancy if in any in the Dhubri district. Hence, the estate respondents are directed to consider the case. Of the
Mr. Kindly come to page number 127.
Yes, my lord.
Read the first opening lines. In the light of Honorable High Court's order dated so and so and so and so, in 982, this is the writ petition you are pointing out.
Yes, my lord.
That is considered. Pursuant to this, the OM is issued. So you, as and when it is available, you apply.
Anyway, you can apply lordship.
In terms of this OM, if it is your case that some regularization appointments are being carried on in violation of this OM, point out.
Now, my lord, some petitioners are going to be retired, my lord, within.
Retired, as per this OM, you are already discontinued.
No, my lord, we are continued till that, my lord.
How do you receive your salaries?
My lord, government providing our salaries, my lord.
In your account?
Yes, my lord.
But this procedure has to be followed. Have you challenged this OM?
We have been appointed prior to this.
Have you challenged this OM? This OM has come subsequently, 2013. This OM, unless you put it to challenge, it cannot be examined. You will have to examine it.
Lordship, kindly have a look at page 26, Lordship, this is petition. The appointment is purely temporary and may be terminated at any time.
That we have seen. That
is always.
And any reason.
Yes. So we'll direct that the government will take steps in terms of this OM and will consider your, you approach the government, they will consider your cases and pass orders in terms of this. And if any other person has been given a benefit, your cases should also be considered.
Well, yes, it is clearly mentioned, my lord, as per the seniority and the length of the service, my lord, their service has been, my lord, considered. It is clearly stated in my OM.
All right, heard, learned counsel for the parties. This writ petition has been filed by the writ petitioner who are who claim to be working as additional Mondal, additional Mondals.
Under the amalgamated establishment of respondent number 8 million.
Under the amalgamated establishment of the settlement officer of Kokrajhar and Dhubri. Stop. The petitioners claim that they were appointed as additional Mondals with effect from 1992 and have been working as such. However, in spite of vacant posts available, their cases are not considered for being regularized.
My lord, 1992, 94 and 98, my lord.
All right.
Several appointments.
92, 94 and 98.
Yes.
On various dates, in spite of their long tenure of service, they were not considered for regularization. Did you file 982? Was it filed by you? 982. Page number 30.
Similarly situated.
Learned counsel for the petitioner refers to the order dated 6/9/2012 passed in WPC 982, whereby similarly situated candidates with approach to court assailed the inaction of the government for non-consideration of where similarly situated person made prayers for appointment and regularization.
My lord.
The writ petition stood disposed of with the following direction, page 38, second paragraph. Pursuant thereto, several notifications were issued laying down the criteria for absorption. Subsequently,
my lord,
yes.
My lord, in the second paragraph of 36, my lord, these petitioners were working at Dhubri, my lord, but we are working at Kokrajhar, my lord. These petitioners from Dhubri, my lord, we are, my lord, from Kokrajhar, my lord.
All right, all right. Subsequently, in the year 2013, the government in the appropriate department by notification number so-and-so issued an office memorandum dated 23rd of September 2013, whereby the issue regarding absorption of additional mandals was taken up and a set of guidelines was issued. Stop. The said office memorandum as per the said office memorandum, vacancies of Mondal, Patwari, when they arise in a district, the competent officer, competent authority, namely the deputy commissioner or the appointing authority, will call for applications to fill up the same as per the existing rules and procedure. Stop. Learned counsel for the petitioner submits that their cases have not been considered in spite of the long service rendered as additional mandals. It is submitted that similarly situated persons arising from other districts have been considered. Stop. Para. Learned government advocate Mr. Hendick submits that
I'm for the 1 and 2.
respondents 1 and 2 Department of Revenue submits that an affidavit has been filed and it is as per the OM dated 23rd of September 2013 that the procedure for absorption of additional mandals are taken up by the government depending on the vacancies that arise. Stop. MS RB Bora, Learned Standing Council BTC submits that insofar as the BTC is concerned, the absorption will be restricted to those additional mandals who are appointed or working within the BTC area, as it is within the 6th schedule. It is a 6th schedule area. Anyone else? Mr. J.K. Goswami also appears for the petitioner. For the respondent. Stop. The learned counsels have been heard. The pleadings have been carefully perused. It is seen that the grievance of the petitioner are that their cases for regularization under the various deputy commissioners have not been considered in spite of their services as additional lot mandals. Stop. The petitioners also claim parity with other similarly situated persons who, according to them, have been considered and regularized. Stop. In spite of several representations and steps taken by the petitioner praying for regularization of their services have not yet been considered for regularization. Stop. The petitioners are shortly, the petitioners will shortly reach their superannuation age and pursuant thereto, their chances of being regularized will diminish. Stop. The issue regarding regularization of additional mandals have been taken up, have been dealt with by coordinate benches of this court, and several orders have been passed. However, the office memorandum number so and so dated so and so, which has been brought on record by the Department of Revenue, reflects that the various directions passed by this court in the orders dated so and so, so and so, so and so, passed in so and so, have been taken note of, and thereupon the office memorandum lays down the guidelines. Stop. By the said office memorandum, in view of the guidelines issued by this office memorandum dated so and so, earlier guidelines have been treated to be cancelled. Stop. The office memorandum dated 23 September 2013 is extracted below. Stop. A careful perusal of the office memorandum reveals that as per the guidelines, the vacancies of Mondal and Patwaris will be filled up by calling for applications as per the existing rules and procedures. Stop. The guidelines also prescribe that due weightage and preference will be given by the selection committee to the services rendered as additional Patwari or Mondal. Stop. There is also a provision for relaxation or condonation of the upper age limit. The guidelines also prescribe that there is a provision for protection of pay of the additional Mondal or Patwari on being appointed as Mondal or Patwari in the respective deceased permanent establishment. Stop. Under such circumstances, we find that the claim of the petitioner seeking a direction for regularization of their services cannot be issued, rehearse the office memorandum number so-and-so, dated so-and-so. Stop. This particular office memorandum is not under challenge in the present proceeding. Stop. It is further not the case of the petitioner that this office memorandum is in conflict with the rules or regulations relevant for appointment of or regularization of Mondals. Stop. It is also not the pleaded case of the petitioner that the competent authority had on earlier occasions taken a partisan view in regularizing similarly situated persons and of legal rejecting the cases of the petitioner. Stop. Under such circumstances, we find that ends of justice will suffice if we close this writ petition with a direction to the respondent authorities to look into the grievances of the petitioners, and in the event the department proceeds to fill up the vacancies available for Mondal and Patwari, end of league or absorb the additional Patwaris or Mondals as regular Mondals or Patwaris, the claims of the petitioners will not be overlooked. Stop. On the other hand, the petitioners are also at liberty to approach the government by filing necessary representations. We are putting it if you want to consider their claims in terms of the office memorandum dated 23 September 2013. Who is to consider this? Will consider their claims? The DC.
BTC mailer?
No.
Because we are from BTC mailer.
On one thing I want to clarify, Lordship. They are
The-
under
the-
Commissioner District, Lordship.
The respective, the competent authority in the district.
Yeah.
No, who is the competent authority here? We'll direct the secretary, revenue and disaster. The respondent number one, namely the secretary, revenue and disaster, commissioner and secretary, revenue and disaster, will look into the claims urged by the writ petitioners in respect of their absorptions into the cadre of Mondal and not Mondal. And upon looking into the grievances, pass appropriate speaking order. Stop.
Lordship given 1 and 4.
1 and 4.
Principal Secretary.
All right, 1 and 4.
Lordship, I want to clarify one thing, Lordship. They are not working under BTC area.
Let them clarify.
Lordship, 124 page, Lordship.
Let them clarify that.
Lordship,
Let them say that they are not.
their affidavit saying, Lordship.
Huh?
Last affidavit, Lordship, page 24.
Page
24, 124.
24 or 124?
124, Lordship.
Huh.
First paragraph, last portion, Lordship.
Huh.
Petitioner who were appointed in the Kokrajhar district BTD have not yet been regularized as Lat Mondal now. They are working as additional
So
Mondal.
it doesn't say they cannot be regularized.
Athani and Mankasar revenue circle under Dhubri district. They are
In
not
the year,
working under
in the year
Beneficiary also.
2021.
It is not, it is not specified, it is not pleaded that they cannot be regularized. The competent authorities, 1 and 4, will no, we'll say only one. Respondent number 1 will look into the grievances if it is found that their cases are required to be considered by the principal secretary BTAD. Then the respondent 1 will ensure that the papers are placed before the respondent number 4, and thereupon the respondent number 4 will consider their claims and pass appropriate orders disposing of their applications. The representations be the cases, the directions contained in this order shall be carried out within a period of 60 days from the date of receipt of a certified copy of this order. Writ petition stands disposed of. What is it?
This is case claiming for
Disability benefits.
Yes, madam. Lordship, I'm very sorry, Lordship. I apologize, Lordship. I somehow misplaced my instruction, Lordship.
All right.
Can it be on Tuesday or Wednesday, Lordship?
It is submitted by learned
Wednesday, Lordship.
DSGI that the matter be taken up on sometime next week, in which date we will furnish the necessary instructions. MS as Pora does not object to the prayer made. It's taken on
Wednesday, Lordship.
have it on 9th.
That's
9th. Please on 9th.
In this case, SK Mehta is appearing on behalf of the central government. He's in bereavement. So, he's on leave till 5th.
This is what mediation.
Mediation, it is failed. The mediation report has come.
Mediation failed.
Moreover, I am for the respondent wife. The matter was sent to the conciliations, negotiation before the district legal service authority. They have submitted a report with an order or with an order by the secretary legal service authority.
This is what matrimonial matter.
Matrimonial.
Report is not on the record, my lord.
Not actually matrimonial. It is basically there is a provision under the Air Force Act, Section 92. If the wife pays for maintenance with the competent authorities, is empowered to grant maintenance. We have challenged that.
Okay.
It may be fixed after vacation along with the direction to register to place the mediation report in the record, my lord. Order is here to
Mediation report is not here.
Not here, my lord. Mediation report is required, my lord. We will see what is the modus operandi of the petitioner before the mediator.
Probably, in cases where the mediation fails, they simply send a report that it is paid. No further observation is given. In case of the mediation is otherwise allowed, then the agreements and all this are part of it.
It is submitted by the learned counsels at the bar that the mediation between the parties had failed as per the report of the Secretary Guwahati High Court Mediation Center, which is available in the order sheet, note sheet. Stop. It is the matter be listed for admissions. You say there is some other writ petition?
No.
Okay. let the matter be listed in on 20th November 20. 20.
Maybe after vacation,
After vacation.
Which November?
May I please the lordship? My lord, this matter pertains to my lord. Already the petitioners appointed as my lord, Pion cum Chokidari India year of 1992, my lord. During pandemic, my lord, some other similarly placed persons approached before this honorable court, and this honorable court, my lord, and considered their case, and accordingly, my lord, the authority has regularized their service, my lord. Even, my lord, some other junior similarly placed persons as well as some other juniors, my lord, their services has already been regularized. So, my lord, kindly, my lord, I'll have to take the lordship Annexure 1, page 26, my appointment first.
You are working as what?
Pion cum Chokidar, my lord. Page 26. My name is Tajid Ali Bepari, my lord. Has joined as Kokalaki Cow Panchayat office as Pion cum Chokidar, 4th grade, an employee on 19/11/1992. This is my lord and original at page 27.
Yes.
Then your lordship, page 28, Annexure 2. This is a certificate issued to me, my lord. The Chief Executive Officer, Dhubri Jilla Parishad. Then your lordship, kindly have a look on page 29, my lord. Annexure 3, 10th January.
So where is your appointment letter?
My lord, Annexure 1.
This is the joining letter.
My lord, this is the copy, my lord. By the date of, I have joined this, my lord.
You have joined, but where is your appointment?
That's very date, my lord. I have stated also my paragraph petition. And
All right, maybe Annexure 2 we can take note of.
yes, absolutely, my lord. Page 28, Annexure 2.
Yes,
Then,
then
my lord, page 29. I've been allowed to draw the regular pay scale, my lord, engaged 10 January 2020, my lord. Allowed to draw fixed wages, remuneration 15,000 so and so with DRS allowance. Your lordship will find my name at page 30, serial number 21.
okay.
440 Talpion 1992, my lord. Then your lordship, some other similar placed persons approached before the honorable court. That order I have enclosed here in Annexure 7, my lord. Page 54. WPC 902/2017 and order at page 60. This and my grievance also covered by this judgment. All the issues discussed here, my lord, elaborately by this one. Ultimately, my lord, certain question raised, my lord. Yeah, my lord. Operative person raised by the government, my lord, at page 64, para 10.
Yes.
The Learned Council Finance Department, while endorsing
This is the submission.
Yes.
Take us to the
then my lord,
operative part.
person. Yes, operative person.
Findings.
Findings. I will take your lordship there. Page 67, para 17. Considering the process that has been taken place, file number so and so, and also taking into consideration the grounds taken by the respondent number 3 in the impugn order dated so and so for rejecting the case of the petitioner for the regularization, this court is of the concerned opinion that the respondent number 3 had not considered the case of petitioner in its proper perspective while passing the same. According to the order dated so and so are set aside, the matter is remanded back to the respondent number 3 to reconsider the case of the petitioner afresh, taking into consideration the process that has been taken place, file number so and so, and thereafter pass this pecking order in accordance with law. Let such exercise be taken and completed within a period of 1 month from the date of the receipt of the copy of the orders of this court by the respondent number 3. Till the pecking order is passed by the respondent number 3, in terms of the court's order, the respondent are directed not to fill up the post held by the petitioners in terms of the advertisement that is so with the observation and direction this petition are disposed of. Then, my lord, non-consideration of this order, this contempt, this contempt court is passed order, my lord. Page 68, Annexure 8. A lordship will find the order, my lord, at page 74. The lordship, due permission, I like to read this order, my lord, from para 2. By the judgment that the thus I have read, my lord, 16/5/18 WPC 902 and other petition in paragraph 15 has been provided, extracted below. The further, with regard to the contention of the petitioner were not appointed by the competent authority, this court is of the considered opinion that since the appointment engagement were within the knowledge of the respondent, and in fact, they have taken a decision to regularize the case of the petitioners in file number so and so. This would clearly demonstrate that the respondents had the knowledge about the same, but had instead taken decision of to regularize the petitioner. Further, taking into consideration the action of the respondents and also the fact of the present case, in the considered opinion of this court, the appointment of the petitioners cannot be termed as illegal but for irregular. This view has also been taken in the case of Amarkant Rai versus so-and-so, Bihar so-and-so, insofar as the office memorandum dated 27/6/13 issued by the Finance Department is concerned. This court is also of the considered opinion that the same cannot cover the case of the petitioner inasmuch as the same cannot be given retrospective effect. Be that as it may, the petitioners fulfill all the requirements that are envisaged in OM dated so-and-so. The contention of the respondent that the petitioner were not granted to the sanction post is belied by the communication dated 11/12/2000 written by the Director of Panchayat and Rural Development addressed to the Commission Secretary Government of Assam PNRD Department, wherein it is clearly indicated that the petition of working against the sanction post, vacant post, this communication is annexed to the additional affidavit filed by petitioner number 7 WPC so. The second sub-paragraph of the paragraph 15 at the executed above marks, it is discernible that the writ court had accepted the factual situation that the petitioners in the writ petition concern were appointed against sanction post. There is a judgment in the division bench of this court dated 8/6/2007, writ appeal number 4514, wherein certain directions were issued for financial benefit to those pastoral workers who were working for more than 10 years, but without sanction post in the prescribed form. That aspect of the division bench order provided in the court of dated so, which was purportedly in compliance of the judgment dated 16/5/18 WPG 902, and other petitions the respondent contender had observed as under. In pursuance to the judgment dated Honorable Guwahati High Court dated 8/6/17.
Yes, so they were regularized.
Yes, my lord. My lord, that regular lordship will find page 77, my lord. Page 77, 29 June, my lord. Above the
Yes,
paragraph above
what
the
do you
chart,
say? Who's for the department?
PNRD department, my lord.
So you say that you are also similarly placed.
Yes, my lord.
But your cases have not been considered.
My humble submission.
You were appointed prior to 92.
92, my lord. My humble submission, my lord. Very Muslim states, my lord. I value representation, my lord. I also belong to that category. But my lord, this honorable court has directed that during pandemic, it shall not be part to consider. If they consider examine my all the documents, whether I am entitled or not, let them consider my case, my lord. Palace speaking order on that, my lord.
Yes. Okay, hard learned counsels for the parties. All right, we'll pass orders. Yes.
I'll just one thing. We've actually given him minimum pay scale, madam. We've actually given him.
Have you read the orders of the court? There are orders of the court passed earlier.
Yes, ma'am.
Have you read it?
Yes, ma'am.
So if you have read it, then your stand of giving minimum scale of pay has been overlooked. Because minimum scale of pay is in respect of people who are not appointed against sanction post.
Yes, that is the
So you'll have to verify.
And
You'll have to verify and say.
two pages on the other. One is page 65.
Yes.
Page 65, lordship will be there, that three conditions. A, B, C.
60.
65, lord.
65. Six five, yes.
Three conditions are there. This is the 2013 notification. If these three conditions are fulfilled, then the portal will be regularized. What you could see the last page of the page 67. The specific direction was the matter is remanded back to the response number 3 to reconsider the case of the petitioner, taking into consideration the process that has been that has taken place file number PK 9/2001. Not a blame them or lordship will peruse this file note PK 9/2011 2001 field is therefore. Some persons are working against sanction tempo.
Let the department make that exercise and pass orders.
Yes, Lord. No, why I am submitting lordship, they have given
We are not saying allow.
Given the minimum pay scale because they are not working against sanction. That is the reason the minimum pay scale.
That appears to be prima facie not correct because There is even in the affidavit file, there is no statement that they are not working against
I was
sanction
saying
post.
that not. I was also got the opportunity to go through this fine lot. And I know petitioner was not appointed against the sanction bank.
If it is not, the authorities will pass appropriate orders. We are only asking them to examine their case in the light of the orders already passed, including the contempt order. Because their affidavit does not disclose anything. Their affidavit, there is no stand that they are not appointed against sanction post. And I don't see any reason what is the purpose of filing an affidavit like that. Why? Disposed.
My only clear mirror. My representation page 80 annexure 11 is pending. Oblige me.
Order dictate করে দিন।
May I please your lordship? May I please your lordship? In this matter, as the Amguri Municipal Board, Amguri Municipal Board, he dismissed the service of the petitioner lordship. According lordship, as directed us, we are basically municipal administration lordship, to get the record from the municipal board lordship. We have communicated. In fact, the municipal administration also communicated the municipal board to hand over the record, but it is still awaited lordship. So the record basically of municipal board, Amguri.
When is it likely to be? Have they responded to your communication?
Yes. They have in fact communicated to the municipal board lordship.
No. Has the municipal board communicated?
No, municipal have not contacted.
You are very happy about it.
We are not happy.
They are under your department. What kind of a supervising department you are that they don't respond to your communication? Why have you not taken action against the responsible officers? You want the court to do the job for you? When was the letter issued?
28th September 2026. 20 September.
20.
20.
All right, we'll give you 1 week's time. You find out what is there, or we are passing not only orders against the municipal board, we are passing strictures against the secretary of the department for being incompetent.
If the lordship wishes to see the
Administration to
paper,
get the records as called for by the court. We are not interested to look into. You are presenting a communication to say we have communicated.
No. We are basically what it says.
Mr. C.S.
And
Burwal,
requested to
Cabinet Advocate, prays for and is granted 10 days further time to procure the records as directed by this court by the earlier order dated 13/9/2023. It is submitted that communication has already been issued, but the transmission of the records by the municipal board is awaited. Mr. So-and-so appears for the petitioner. List again after 10 days, give a date. 16th October. Please get the records.
May please your lordship. But in this case, the petitioner of your lordship was initially appointed as block MS manager. Therefore, his service was terminated 1/7/2016. The termination order was set aside by the Honorable Court, my lord. Right, order dated 14/5/2018. That order will also find at page 21.
Yes.
Relevant portion is page 24.
Why were you terminated?
My lord,
Page number?
termination order will also find page 19.
From contractual engagement.
Yes, ma'am.
Where is the agreement? Where is the agreement?
That was put to challenge before this Honorable Court, my lord. This Honorable Court has already set aside that order, my lord.
Yes, and then what happened?
My lord, page 24 is the relevant portion of the order, my lord.
Yes.
Last paragraph, my lord. In
Reinstate. To reinstate you.
Reinstate.
Then?
what they have done, my lord, I have been reappointed, page 26, instead of reinstating me. Counting my service from the date of my lord, reappointment, for which my lord, I am getting lesser pay.
What benefits do you get by the length of service?
Length of service, what will find,
No, what benefits do you are accrued?
my lord, the persons who are my lord, appointed initially along with me, my lord, they are getting my lord, 22,000 per month. I am-
Financial benefits?
Yes, my lord, I am getting to 20,000, my lord.
Yes, madam.
But the affidavit is sent for vetting, so need 1 week time may be granted.
Please convey that this order appears to be prima facie contumacious. There is an order directing him to take back reinstate. The word used is reinstate.
No.
And you have decided to appoint him. Please inform your project director that this is contumacious prima facie. So your affidavit, which you have sent for vetting, must contain the reasons why he was not reinstated.
Lordship, he is reinstated on 28 2018. 2018. And in Lordship, kindly page number 27, here said his service was not 2 years completed. So he is got 20,000 per month. Annexure 7.
Where have you said? Annexure 7.
Annexure 7. Approved fixed remuneration for contractual employee from 0 to 2 years completion independent. Because he is reinstated on 28 2018. So his service period was not completed 2 years. So he
No,
is,
but you have reappointed him. The direction of the court, kindly come to page 24. Kindly see the last paragraph. Have you found page 24 of the?
Lordship, we have received instructions. So however, considering the nature of the case, this court is not inclined to give any direction.
Before that.
In view of the discussion main herein above, this writ petition succeeds, and accordingly the communication dated 1/11/2016 written by the respondent number 4 and the order dated 12/2016 passed by the respondent number 5 are set aside and quashed. The respondents are directed to forthwith reinstate the petitioner back
That's it.
into his contractual agreement.
There is a direction.
That's it. His,
There is a direction to reinstate.
Lordship, he is joining. Now he is joining.
There is a difference between rejoin
Re-
and reinstate. There is a difference in service jurisprudence. So when the direction of the court is to reinstate, you cannot bypass that order unilaterally and pass an order that he was reappointed. Unless you want to say this use of word reappointed means reinstated. You get your clarifications. I heard learned counsels for the parties. This writ petition is filed by the petitioner putting to challenge the, which order? 26 order,
My lord.
page number 26. Seeking a direction from the court that the petitioner was reappointed as what contractual employee under a contractual employee block MIS manager PMGY under so and so, page number 26. Stop. Grievance of the petitioner is that his termination order was earlier challenged before this court by way of WPC number 5611/2017. In this court, by order dated 14/5/2018, allowed the writ petition and directed the respondent authorities to forthwith reinstate the petitioner back into his contractual engagement. Stop. The writ court, however, declined to give any direction for payment of back wages. Pursuant thereto, the petitioner, learned counsel for the petitioner submits that instead of reinstating him, he was reappointed. And he was required to submit a joining report, as is evident from the order dated 16/11/2018, issued by the Project Director, District Rural Development Agency, Kamrup. Stop. Learned counsel for the petitioner submits that this order was passed in contravention of this earlier order passed by this court by coordinate bench by the order dated 14/5/2018 in WPC so and so. MS N. Bora, learned standing counsel, PNRD, submits that the affidavit will be filed shortly, as the same is as the instructions are received, and it is likely to be filed within a short date. Stop. You are appearing for Deputy Commissioner. Mr. C.S. Borwa appears for Respondent 3, Deputy Commissioner. Stop. Let the matter be listed after 2 weeks, on which date the learned standing counsel PNRD will obtain instructions from the concerned department as to why, in spite of specific directions contained in the court, specific directions in the order dated 14/5/2015 in WPC 5611 of 2017, directing the respondents to reinstate the petitioner, was not given effect to, and instead the petitioner has been reappointed. Stop. Matter be listed after 2 weeks. You have joined. All right, after 2 weeks, please get your instructions. Date may be fixed. Give a date. 18 October.
Fine.
Yes.
Please, Your Lordship. This matter pertains to Lordship. Here in this case, Lordship, we had submitted filed our affidavit on behalf of respondent 4 and 5, Lordship. And another affidavit is required on behalf of respondent 1, Lordship. Kindly accommodate 2 weeks time, Lordship. We will submit the.
Yes.
Okay, that is important because the state is here to file their.
Mr. J.K. Goswami, learned government advocate, praised for and is granted 2 weeks further time to file the response on behalf of
One, Lordship.
respondent 1, namely the Commissioner and Secretary Home within bracket B, Department Government of Assam. Mr. K. Monto appears for the petition. List after 2 weeks.
Okay, one prayer is there. Okay, response number 2, the finance department stand is there to be brought up. The finance department, they have not filed it because
Other respondents are also at liberty to file their counter affidavit if so advised. 6 November.
Obligor.
List on 6 November. Right.
Please, Lord. Please, we need some time to file affidavit. I am applying for response number 2 and 3.
You are filing as a petitioner in person.
Yes, sir.
Who was your counsel?
Sir, Mr. Pawan Body.
Have you issued any him a letter disengaging him?
Yes, sir. He already he already submitted NOC. Sir. I have already submitted along with my application.
All right. Mr.
M. Google.
No, no, your name?
Obinash Bora.
Avinash Bora appears as the petitioner in person. Yes, Mr. Gogoi, what do you want?
We need some time to file affidavit.
We means you are appearing on whose behalf?
Respondent number 2 and 3, Lord.
Respondent 2 and 3. Mr. Bora, what is your claim?
Sir, they have all, Lordship, they have already got 7 months time to file the reply affidavit. And last 2 times they have already taken time. And my I have a specific some pairs to this honorable court. If you kindly allow me to place it, I can take it.
Anyone for respondent 4, 5, and 6?
Not yet. Lordship, they are the primarily responsible to issue these illegal orders and imposing contradictory and false allegation as well as manipulation of issue. So I request this court and Lordship to you so that I can get specific response from the respondent number 4, 5, and 6 against each point of the petition.
You are terminated.
Yes.
Where is the order of termination?
Page number 589, Annexer R.
You do not want to be led by an advocate. Do you want the court to appoint an amicus curiae?
Lordship, I have faced lots of inconvenience in last 1 year. I have written all those things in my.
You don't have to worry about payments. The counsel will be appointed by the court.
At present, I would like to continue and pursue my case as a petitioner in person.
All right. Where is the termination order?
First termination order was in Annexer R1, RR page 589.
Page number?
589.
There are only 200 something pages.
There are 3 volumes. That is only the read petition.
What have you enclosed in this petition, in these volumes?
That's why affidavit while preparing is taking time.
500? 500?
89.
89. 589.
Volume 3.
Volume 3.
Volume 3. Volume 3.
Yes. Yes. Page 580 is passed by whom? Order 589. Yes, Mr. Gogoi.
Yes.
589 is issued by whom?
589.
Disciplinary authority.
Disciplinary authority. Disciplinary authority.
Lordship, he took the disciplinary authority illegally. He do not have that required designation.
You did not participate in the inquiry proceeding.
I participate. I physically present and I replied in written form. After that, they falsely imposing some misallegation that I did not participate. I participate there, but they did not consider anything from my reply as well as whatever I said in the inquiry. It is a totally a false allegation, and it's totally violated CTA company CDA rule. Because company CDA rules only want physical presence as well as written statement. Both are I have already complied. The rules which are imposed against me that are not actually existed on that are already amendment, but they did not refer the new rules, but they refer the old rules of it.
All right, we'll hear it. You are absolutely sure you do not require to be the assistance of a counsel?
At present, sir, I do not require. At present, I continue as a
All right.
petitioner.
Heard counsels admit list for hearing. The learned counsel appearing. Sorry, you have not filed your
No.
affidavit. All right, then can be it. List for admission after 2 weeks.
After
Why?
it's very voluminous.
They have already
These are
taken 7
documents
months.
issued by you only.
No, the read itself is 260 pages.
They have already taken 7 months time.
You take the help of your clients, officers,
I have
ask
received the
them
instruction.
to
Lordship.
read it and
I'm-
explain to you.
Lordship, after 3 weeks.
All right, 3 weeks time to file their affidavit.
I think providing fixed date. Provided fixed date. Sir.
I didn't get it. Sorry.
If a fixed date can be provided.
Fixed date, yes. Fixed date. 8th November. All right, list on 8th of November.
All right.
8th of November.
Lordship, I have another pair. Some amount of salaries as well as my medical benefit were held without any disciplinary action as well as penalty.
If any medical, reimbursement, medical reimbursement or any amount of salary or other dues are left to be paid to the petitioner, the pendency of the writ petition shall not be considered to be a bar, and the department will examine and release any such payment that may be pending. Mr. Deka, we've given you 3 weeks time to file your affidavit. And if any claim is due, kindly release it.
If any fixed date can be given to the
We had given you 8th of November.
For the respondent authority to release the salary.
No, you go and approach. You go and approach. First, let them find out if there is any salary or any benefits left to be released.
Without any discipline.
All right. You examine this before the next date.
My lord.
8th. On 8th, you inform the court what is the status with regard to his claim for any area salary or medical benefit.
I'll try to file my affidavit, my lord.
No, that apart, if there is any claim due, you inform us.
Yes,
If it is there or not.
Record.
On the next date, they will inform the court whether any claim is due, and if it is due, they shall release it.
But I already give a request that I need a specific reply against each point of the petition, and from the respondent number 4, 5, and 6, who are the primarily responsible.
We have given them opportunity to file. Whether their replies are specific or non-specific, we'll examine and pass appropriate orders.
4, 5, and 6 are yet
4,
not
5, and
responsible.
6, the
Yet not
services are
responding.
complete, notices are complete. The office note reflects that they are represented by councils, but I don't see any councils appearing for 4, 5, and 6. So once the councils appear, file their power of attorney, which is called Vakalat Napa, they are expected to appear before the court. If they don't appear, we proceed ex parte. List the matter again on 8th. 8th of November.
8th of November.
Doctor, I have some written pairs. Can I submit?
On 8th. Give it on 8th. None appears. Passed over.
In 37, Lordship. We are waiting for 37.
I always thought I had a loud voice, so I tried to speak as softly as possible anyway. I could be wrong. Yes. Is it not audible?
It is not 37. Somehow we have not heard.
Yes.
The last question, there were two issues which were what to be answered, my lord. One is the data jurisdiction part, which I have to answer, and the second, my lord, was to the earlier court of inquiry which was held, the details of the earlier court of inquiry which was held by the respondents, my lord. The details of that inquiry was sought for by this honorable court to determine whether is a court of inquiry being again held in the same subject matter, despite the fact that the circular of the respondents themselves debar holding of a inquiry on an anonymous complaint. What had happened is, my lord, while the petitioner was serving in Ladakh, there was an anonymous complaint regarding theft of some barrels of kerosene oil. A court of inquiry was held under the orders of the Deputy Inspector General of Police at that point of time by a commandant, where, my lord, I had not participated. The petitioner, who was one of the accused, he did not participate, and yet there was a report, inquiry report, which had exonerated the petition and said that the incident was one which could not have taken place because of the snowfall. 25 barrels of kerosene could not have been carried by a single truck on that night, and nothing, there was no evidence which said that there was any displacement of any kerosene. The petitioner was then transferred to Guwahati. While he was serving here in Guwahati, on the basis of the same anonymous complaint, a second court of inquiry was being initiated. It is at that point of time, my lord, we had approached this honorable court on two grounds. One, court of inquiry once held and an exoneration given, de novo court of inquiry is prohibited by law. Secondly, the additional director general has issued memorandums based on the CDC recommendations that there would be no action taken on any anonymous complaints. This honorable court was pleased to stay the proceedings, and they were required to file their affidavit in opposition. They filed their affidavit in opposition. They filed a application also for vacation of the state. Then, my lord, this honorable court has asked for the details of the first court of inquiry which was held, because if it was a court of inquiry which was held as alleged, then the de novo inquiry would not sustain. My lord, that part of the court of inquiry report I do not also have as to who had initiated it, and I only have the final inquiry report which I have given with my petition. So, in case, my lord, the records are available, perhaps if I am given a chance to go through them to find out whether the earlier court of inquiry was an inquiry as I have alleged in my petition, Then the argument should be on the other
That
hand.
is, that we cannot help you there. It is up to the learned counsel to consider whether your records can be, you can be allowed to peruse the records.
Then their allegation is it was a preliminary inquiry. Unless they produce some records or give some.
Lordship, original
something
record
before-
is with me. I will definitely place it before your lordship, because on the last occasion, that is the direction. And mostly, lordship, we have objection to the point of jurisdiction. The whole cause of action arises in Leh and Ladakh when the petitioner was posted there. I have an X number of judgments, lordship, where it is stated that the jurisdiction is where cause of action or either part of cause of action has to be arises, lordship.
Now
Mayor,
you are a resident of this,
I
you're
am-
posted now.
I'm posted here.
only
Here.
posted.
I'm posted here.
Then what were you doing in Leh and Ladakh?
My lord, I was at that point of time. I was when the first inquiry took place. I was posted in Leh and Ladakh.
Then?
When the first allegation came, I was in Leh and Ladakh.
Hmm.
Then I was Then I was exonerated. I was posted to Guwahati. Now they start the second court of inquiry.
It's not a second court of inquiry. That is only a
is why the
preliminary
records-
inquiry.
So, but that is after he's been
No,
posted.
that is
Yes.
only a preliminary inquiry, and court of inquiry was prior to after that, lordship. But it's the cause of action, and Supreme Court also stated that the cause of action is not where he is at present resident. Here he is not a resident also, lordship. He is only posted because his battalion is here, lordship. But the incident is there, lordship, and everything is there. Cause of action, and now the record we have called for, that is also from Leh and Ladakh. And the petitioner is informed in similar case earlier also, lordship. That is pending there, lordship. Our case is that, lordship, that the incident took place in Leh and Ladakh, and it's only
Where was the second show cause notice served?
What?
it was issued from Leh and Ladakh.
Served.
Here.
Served.
He is
Guwahati.
posted now here.
Served.
Guwahati.
Supreme Court judgment is the posting, lordship. I have
No, but you have served him here. He's not on leave
No.
at home.
But he is not a resident also, lordship. He
You know,
is only a-
that's the precise reason he is employed. He's in Guwahati by virtue of his service.
lordship.
So you have served the.
But the cause of action and that mayor posting.
Where
of
is the
resident-
inquiry held? There.
There.
Yes. Cause of
There-
You are
action-
required to participate there.
My lord, they want me to go and participate there.
It's-
My lord, if I go to the exact point of a cause of action, my lord, whatever I need to prove to show that I want a relief from this court is where the cause of or a part of it will arise. The ADG here has issued the office memorandum which protects me, which debars such a inquiry to be held on the basis of an anonymous complaint. It is a part of the cause of action,
that is an
and therefore
You show us that mayor service of notice or show cause.
finish those judgments in my affidavit.
none of them will.
All right, then we'll put it for admission hearing on this
There is
point.
already an order to dispose it at admission hearing stage by the order dated
All right, so
1970.
let us have it on a hearing date for
Lordship.
admission hearing.
Can it be on fifth, lordship?
No, fifth time not. I made it.
Matter be listed for admission hearing, and the question of maintainability of the writ petition will be taken up at the admission hearing. List on.
He has problem on fifth. Then in 10th, lordship.
10th, 11th,
10th is a Tuesday, na?
9 তারিখে রাতে এই পাবো।
Opo, ito na.
রাতে কথা বলবো।
16 November.
16 this week I have personal problem.
November.
November is too late, lordship. Lordship, kindly take up one day prior to vacation, lordship.
One date.
No, one date means one day at least
The
listed
last
on
week will
10th,
be-
lordship.
last-
Kindly on 10th,
No,
lordship.
this we can take it up, but then we do not know whether it will be
That's a different issue, lordship. At least 10th. Let it
10th is not possible.
then 12th, lordship.
We can hand you over the docket list. You can have
No,
a look
I
and
can
choose your
understand, lordship.
dates.
I have some difficulty, lordship. That is why I'm requesting.
On 12th, there are 20 matters for admission hearing. Yours will be 21st.
2-3 benches. So any benches, lordship.
All right,
Records are here.
12th, as
Lordship.
requested by the learned counsel. Matter will be listed on 12th of October for admission hearing. All right.
Obliged.
Well, the interim continue.
Interim prayer will continue until further orders.
Obliged.
Yes,
May it pleases your lordship. Lordship, I am appearing for the respondent number 4. Lordship, we need 4 weeks time to file affidavit in opposition.
yes.
I am for the petition amendment.
I know they made a prayer. Any objection to that? All right. Learned Counsel, MS so-and-so, praise appears for
Respondent number 4.
respondent 4, who submits that she'd like to file an affidavit in opposition. Yes, PWD, who appears? Mr. Aadhar appears for the PWD.
Yes, Lordship, in this case, we have received the.
Okay, Mr. Nayak appears for the PWD, who also submits that affidavit will be filed.
Signed
Since
copy you have received, but it is in a courtesy record, I mean, legal size record. We have.
he has,
What kind of record?
Uh,
We'll file it, sir.
we'll file the affidavit within 2 weeks.
Lordship, 4 weeks.
4 weeks.
Yes, your lord.
Why? 3 weeks to be filed. Mr. So-and-so, Learned Counsel appears for the petitioner. 3 weeks.
That may be.
No.
Any date.
Let the affidavits be filed. You may like to file a reply. So what is the point in fixing a date? Let the affidavits be filed.
Obliged.
Wait, please, my lord. My lord, I seek some time to file our affidavit, my lord.
Prayer for adjournment is made by the counsel for a PDCL, not objected to by the Learned Counsel for the petitioner. Matter stands adjourned for 2 weeks.
My lord, to file, not adjournment, my lord, to file our affidavit, my lord.
When?
My lord, after 4 weeks, my lord.
No, 4 weeks.
Matter will be listed after 3 weeks, enabling him to file their affidavit.
Oblige, my
Lord.
Lordship, in this case, Lordship, in the earlier order, Lordship, a direction was given to us for taking the instruction, Lordship, but instruction not received, Lordship. Can you fix the matter in the next week, Lordship? I will submit.
What instructions?
Lordship,
They have already filed affidavit. I have annexed the affidavit in this. This second petition is filed only for technical reason, Lordship, because the coordinator bench has stated that earlier we have filed this petition in the name of the association. And there is a Supreme Court decision that Lordship, that promotion matters cannot be filed by an association. That is why we have filed the second petition. Their affidavit is already on record, Lordship.
Where?
Yes, Lord.
In this writ petition?
In this petition, Lordship, page 89, Lordship. Page 89. There's 10, Lordship, is in page 91, Lordship.
This is in 1492.
Yes, Lordship.
Then
1492, Lordship, the subject matter of the writ petition is same. That writ petition is also pending.
Mr. Counsel, how can it is for them to say that this we are relying on this affidavit?
yes, Lordship. The order dated 30/08/2023, Lordship, this honorable court categorically stated in the last paragraph, Lordship, TC Sutia Learned Standing Council, the government is, however, directed to obtain the instruction regarding the steps taken to implement the new scheme, which was disclosed at the time of consideration of the earlier writ petition being so and so and so. There's a specific direction is there, Lordship.
So we have some urgency because from the
You
earlier
file your affidavit within 2 weeks or get your
Lordship,
instructions.
Lordship,
from the earlier
Lordship.
declaration list, Lordship, all the persons have already retired. Lordship, may kindly see page 112, Lordship, for a moment.
What is your claim?
Lordship, we are seeking promotion as FDO.
When are you
Because-
retiring?
Lordship, we have enclosed the gradation list, Lordship. There are 25 number of petitioners. From the earlier gradation list, all of them have retired. Lordship, may kindly see page 112, Lordship.
When are you retiring? You will know. This month, next month.
Lordship, there are 25 number of petitioners, Lordship.
Then-
Retiring.
Mr. J.K. Goswami is permitted 2 weeks further time to file their affidavit.
Lordship.
Considering the urgency expressed by the Learned Counsel for the petitioner that some of the petitioners are likely to be superannuated the department should file their affidavit in response to the contentions raised. Matter be listed after 2 weeks.
Kindly give us a fix that because
Give a fixed date. No, not on 13, too many matters. 18, 18. 18, 10. Yes.
I have made a copy for your lordship. 43. All the 111 petitioners, I have meticulously gone through the instructions. The names of all of them are there. So they are the genuine beneficiaries. If your lordship kindly sees the instructions, the last 2 lines, it says, moreover, the names of the petitioners were included in another 53 numbers of approved list. In fact, my lord, police verification and character antecedents were verified, and all the petitioners were found to be genuine, my lord.
Are your names included here?
Included. I've meticulously gone through each page, my lord.
All right. It is submitted by the, in terms of the earlier order, dated 27/09/2023. The learned standing counsel for the forest submitted before the court that the matter for conferring the benefits on the petitioners in terms of the directions of the court passed in the judgment. Directions of this court passed in State of Assam versus Upendas, reported in so and so. There is a list of 550 names, which also consist of the names of the petitioners. And the department is the matter is under consideration of the competent authorities in the department. Stop. On such submissions, the learned counsel for the petitioner was given time to complete his instructions in respect of the submissions made by the counsel for the respondent. And the matter was fixed today. Today, when the matter is called up, learned counsel for the petitioner submits that the names of the petitioners are indeed enclosed in the list of 550 names as placed before the court by the standing counsel. He therefore submits that the writ petition be closed with a direction to the respondent authorities to expedite the claims of the petitioners. Accordingly, the writ petition stands disposed of, and the petitioners' cases will be considered along with the other names included in the list of 550 names, and thereupon, if found
Already
eligible,
as per the instructions, already the names are there.
if found eligible, the directions contained in para 22 of the directions contained in the judgment of Upenda Supra shall be conferred without further delay. Writ petition accordingly stands disposed of. Mr. Botakur appears for the respondent. Forest.
Let the entire exercise be completed within a period of 4 weeks.
The exercise to be conducted by the respondents shall be completed within a period of 90 days from the date of receipt of a certified copy of this order. Writ petition stands closed and disposed of in terms of the above. Mr. Nayak appears for finance.
Yes.
Finance department.
A copy of the instruction will be kept on the record.
This entire is yet to reach the finance department. This is their internal communication, Lord. That's yet to reach finance department.
As your lordship. Obliged, deeply obliged.
May I please, Your Lordship? The second bail application, my lord, CD was called for.
The CD receipt.
Where is the earlier order?
Lordship, earlier order is page, my lord.
What is the stage of investigation?
Investigation, same my lord diary we have.
What is the state? Charge sheet not filed.
Charge sheet not filed. Here, my lord, the second application, they have annexed one order of this honorable court of co-accused. More than that, nothing, my lord, new.
Sorry?
Here, my lord, some other co-accused already released. They have annexed that order. And more than that, nothing new, my lord, here. But
No.
earlier rejected on the ground that material is available against this person.
So you tell us what is there.
But that is the material, what was the earlier?
No, what is this progress of the investigation?
Progress, my lord, that diary is not, my lord, earlier order was passed on, my lord, 13/6 and diary up to 15/6.
Then why not got an up-to-date diary?
Not updated, my lord.
Get an updated diary.
My lord.
When can you get it?
Before vacation, any date, my lord.
It is submitted by the learned APP that the updated CD is not available, and he craves leave of the court to call for the updated CD. MSP Bora appears for the petitioner. Matter be listed on 18th October.
18/10.
18th October.
No. Before 9/10, after 9/10.
After your lordship.
18th October.
I prefer little early, but my learned senior counsel.
We are giving him about 2 weeks time to update the CD.
We have to return the diary then.
Yes, 18th.
18th.
Matter be fixed on 18th. CD be updated CD as prayed for should be produced along with any injury report, anything required?
No.
Nothing. All right.
All right.
Very pleased, my lord. Service has been completed, my lord. My lord would kindly refer to the office note, my lord. If it pleases my lord may kindly fix it for admission hearing on the next day. File reply file additional file.
Anyone for the private respondents? Your pleadings are, your affidavit is there?
We have
you filed?
I have taken steps, my lord, through rational number 5, my lord. Now they have to file affidavit, my lord, but instead of their filing, I have to file this affidavit as the case is going late.
No, আপনাদেরকে একটু লাস্ট ফেরত ফাইল করলে তার থেকে
আপনাদেরকে দিব লাগে কিন্তু কোর্টের মুখ আপনি দিব
সার্ভিস রিপোর্ট আর এফিডেভিট তো স্যার আপনি নিয়ে দেবেন
তারপর কপি দিতে হইতো আপনাদেরকে কাট করবে লাগে এটা আছে তো পুরো রেশন নম্বর 5 আমি আপনার কপি আপনি রেশন নম্বর 5 ডিসিশন করে it is the last page আপনাদেরকে রিসিভ করে দিতে
In terms of the directions earlier contained, the petitioner was permitted to take. You are permitted to take dusty.
Oh, my lord, pro restaurant number 5, my lord.
Uh,
Pro restaurant already I have
was permitted to take service through the respondent number 5. The steps as directed were taken and an affidavit of compliance has also been filed. Accordingly, matter be listed for admission. List on 14 November. 14 November for admission.
Highly obliged.
Yes, Mr. Chaudhary.
Right. This is regarding promotion of grade 4 employee. The affidavit is in file showing the cadre strength. If then is that part of strength is considered, then I have no case.
Which affidavit?
An affidavit is in file by the PWD department.
Yes.
Yeah.
Who's for the PWD? Yes, Mr. Nath.
But Mr. Nayak is here. Kindly
But-
give us 2 minutes time.
No, affidavit has been filed. Yes, what do you say, Mr. Chaudhary?
What I have read in the affidavit, the cadastre has been shown, the only 3. UD assistant 2 and 1 UD assistant and LD assistant 2. So 10% of the 3, it falls under below 0.5. So, but there is in the affidavit, it was stated the one post is there. Because of not having approval from the authority, they could not consider.
Then also below 5. Then also below 1. So we record this statement and close it? Or you'd like to file a response? All right, heard. Learned Counsel, Mr. D. Chaudhary, Learned Counsel for the petitioner, and Mr. D. Nath, Learned Counsel, Senior Government Advocate for the respondent authorities. The writ petition is filed by the petitioner. He was initially working as master roll worker, and subsequently his services were regularized from time to time.
In 1991, 23/5/91 regularization order. Annexure 4, page 21.
He was regularized by order dated
23/5/1991. Page 20.
Page 20. He was regularized by order dated 23/5/1991. Since then, he's been working in the post of a chowkidar. Claim of the petitioner is that his case has not been considered for promotion to the next higher post of LDA, although he meets the required criteria. Stop. His representations did not yield any result, and therefore the writ petition has been filed. The respondent department has filed their affidavit in opposition, wherein it is stated that the application for the application for promotion to the petitioner was kept pending at the office due to non-receipt of the government's within bracket SIU department's approval regarding recruitment of posts. As per the affidavit, it is stated that there are only 3 numbers of sanctioned grade 3 posts of ministerial staff, namely UDA 1 post, LDA/JA 2 numbers. And there is no backlog vacancy. And there is 1 backlog vacancy of LDA. It is submitted that against these 2 backlog against these 2 sanction posts, there is no vacancy in the category. Under such circumstances, unless there is a clear vacancy, the case of the petitioner cannot be considered for promotion. Stop. Where Mr. D. Chaudhary submits fairly that in view of the affidavit filed with the respondent, the petition can be disposed of by directing the respondents to consider the case of the petitioner for promotion in the event the vacancies are available by following due process of law. Stop. Accordingly, the writ petition stands closed. The respondents, the statement of the respondents, the writ petition stands closed by taking on record the averments made in the affidavit that there at present there is no vacancy. Stop. However, the department will endeavor to consider the case of the petitioner against any sanctioned vacant post available in the cadre of junior assistant /LDA as per provision of law, as and when such vacancy arises. With the above observation, writ petition stands closed. Interim order, if any, stands vacated.
Please, Lord, my lord, this is a order for contempt, my lord. Interim order is page number 27, my lord. Order dated 28/6/2019 for appointment of compulsion and ground, and respondents are directed to consider.
Yes. Order complied, not complied.
Your Lordship, I am newly impleaded respondent number 5, Your Lordship. I have filed my wakalatnama. I will file my affidavit, Your Lordship.
We don't require affidavit. Comply the order. Comply the directions. Page number 29.
Yes, my lord.
29. Reconsideration of the application for appointment within a period of 3 months.
Despite available vacancy that not was complied, my lord.
When were you appointed in the new post? When did you join? You are appearing on behalf of DC Kachar.
Yes, respondent number 5.
When did you join? When were you posted?
That date I am not aware, Your Lordship.
All right, please comply with this order within 3 weeks.
I'll file my affidavit, Your Lordship.
And earlier occasion, they have also filed their affidavit, my lord. Earlier DC. They have filed, but that not complied.
You comply with this
There
order.
we have mentioned in our the minus, Your Lordship. One minus is there.
Have you considered the case?
Due to lack of vacancy, we could not consider, Your Lordship.
No, my lord, there is
Lack of vacancy will require to be assessed by in the meeting. How can you say there is no vacancy, will not hold? There is a direction of the court.
Then there was a meeting on 31/12/2021. There was a meeting, and it was considered in that meeting. But the
31?
31/12/2021. there was a meeting of the DLC. In that meeting, the case of the petitioner was considered. But because of lack of vacancy, it could not be considered. But the petitioner disputes that there are some vacancies. So ultimately, the new
Is
DC
this
has-
minute, is this minute on record?
But, no, this minute copy I have.
They're always trying to mislead the court, my lord. They have stated the
Affidavit
minute of
recent.
21, my lord. But
No,
prior to
21
that,
condition,
2020, my lord, there's a minute, my lord, I have annexed that annexed, my lord.
Huh?
There's 6/3 of 2020, my lord. There's a minute. There is available vacancy. But that's not considered, my lord. Order was 2019.
Do you have a copy of this order?
Yes, my lord, I have a reply, filed my reply, my lord, in the form of affidavit, my lord. That was filed on 24/6/22. And they are always trying to mislead the court, my lord.
Where is that list of vacancies?
My lord, page number 8 of my reply, my lord. And I stated my reply in paragraph number 4 and 5, my lord. In paragraph number 4, I have given a tabular form. Paragraph number 5, also I will give tabular form, my lord. 6/3/2020, that was page number 4, my lord. I have mentioned category, my lord.
190.
Available vacancy under compensation ground.
6/3/2020 is the minutes is there.
Yes, my lord. But they always suppress the text method.
Yes, Mr. Nath.
Lordship, may kindly have a look at the minutes of the meeting dated 31/12/2021.
And the order was passed in the year 2019, my lord. 28/6/2019.
Earlier opinion of the name.
Where is your name? Where is your name in page number 8 of your affidavit? 6/3/2020. Where is your case? Is your case considered?
Not considered, my lord.
Then?
On 6/3/2020, I have given a minutes of 31/12/21.
Yes.
But in that minute, Lordship may kindly come to second page.
Yes.
Orijit Sonar is the first name.
Yes.
He is the petitioner. Now, Lordship will see they could not consider those cases because of lack of vacancy, and they have taken a decision that this will be taken up with the administrative department as to comply with the clause 15 of the OL. Now, in the affidavit and reply filed by the petitioner has referred to vacancies available in the other departments, not in the PWD department, my lord. Page 3 of his affidavit and reply.
But order was passed, my lord, to consider the any other
So,
department.
so as per clause 15, you consider.
Correct. My lord, till 31/12/2021, that progress we have, my lord. The up-to-date position, possibly the new incumbent, he will apply. My lord.
We don't need the position. We want the compliance of this order. That's all.
My lord, Lordship has directed to consider. It is not that his case has not been considered. My lord. It is considered on 31/12/21 also it was considered. My lord.
Have you furnished him a copy of this minutes?
I in fact, my lord,
You give him a copy?
Lordship.
And the earlier organization court was directed them, my lord, to file their affidavit, my lord.
Lordship.
File order that is
Kindly come to page 28 of the contempt petition.
My lord.
29.
my lord.
This was passed in 2019.
19, my lord.
Direction was to place the matter before DLC for reconsideration.
Reconsider
Availability of vacancies in other departments.
other department, my lord.
So this is not in compliance of this direction.
My lord.
But that my lord, has been taken. They have again said that the department will take up with the other department. My lord. Now the petitioner in.
Why are you trying to interpret the order of the court? If you think this is a wrong order, you have remedies in law. But why are you trying to interpret?
No.
Don't interpret court's order. Whatever is there is there.
Correct.
If you are aggrieved, go and appeal. If
No,
you
no.
think there's an error apparent, file a review.
No. Ultimately, what is the.
You
what
file
is
an
the-
application for clarification
No,
if
what
you
is the
require.
progress thereafter, my lord? Let.
The
proceed.
minutes did not carry out the directions contained in this order. Minutes said that it will be taken up against others, but that is precise direction given by the court. You consider the vacancies by examining the availability of vacancies in other
No,
departments.
in fact, my lord, in the other department, if but in the other department also did say that no vacancy available at that point of time in that minority.
Let that be a part of the minutes.
My lord, if in the minute, my lord, I'm just reading, my lord. The executive engineer PWD Sonai so and so placed the above mentioned proposal pending for recommendation for appointment under compassionate ground. The matter was discussed thoroughly and decided that since there is no post available in respective office and also in other offices of the district under the compassionate quota, the executive engineer may take suitable action as per clause 15. In that, my lord, they have also seen the availability in the other offices of the district, my lord. Then my lord, they have said as per clause 15 of the office memorandum, by sending the pending proposal to the head of the department, administrative department to take up the matter with the other departments of the government. That much they have done. After that, my lord, I will apprise, my lord, what they have action taken. They have taken, my lord.
Where is it reflected? Where is it reflected in the minutes that you have considered vacancy? You are asking the other departments to take it.
But there is
Verify
no,
it.
in the third line, there is no post available in respective office and also in other offices of the district under compassionate quota. Within the department, they have seen.
Then you continue.
Then they have said that the executive engineer may take suitable action as per clause 15 of the office memorandum by sending the pending proposal to their
It is not the job of the executive engineer. It is the job of the DC as the chairman of the DLC. He has to take a call. Then
what happened thereafter?
Don't explain all this. You do it or we call the DC. When do we call him? Tell us. Give us a date.
What happened?
Teacher, there is a flight. He can come by flight.
What happened thereafter? Kindly, the DC has come now. He has been impleaded. Wakalatnama has been filed.
Very well, we'll explain to him. You tell him what is required to be done. We'll do it to him in court.
My friend has sought some time for filing affidavit.
For what affidavit? We don't need your affidavit. We want the compliance of this order. You file an affidavit saying that this order has been complied with. That's all. We are not asking you to appoint him. We are saying the directions be complied with. You file an affidavit. Heard learned counsels for the parties. MS, Mr. D. Nath appears for the
respondent number 1.
Respondent 1. MS K. Fukan appears for newly impleaded respondent number 4. 5. She submits that an affidavit is required to be filed. The contempt petition arises out of due to non-compliance, alleging non-compliance of the directions contained in the order of this court, passed order of this court dated 28/06/2019, passed in WPC 4477 of 2019. By the said order, the writ petition was disposed of with a direction to the respondent authorities to place it before the concerned DLC for reconsideration of the application of the petitioner for appointment under the scheme by examining the availability of vacancy in other departments as provided under para 15 of the OM dated 1/6/2015. Matter was directed to be considered within a period of 3 months from the date of receipt of a certified copy of this order, or whichever is earlier. Learned counsels appearing, para learned counsel for the respondent department submits that pursuant thereto. A meeting was held on 31/12/2021 and in the said minutes, case of the petitioner was considered. However, there being no vacancy under the executive engineer PWD, Silchar, Sonai and Dholai territorial building division, Silchar, appointments could not be made under compassionate scheme. Stop. Copy of the minutes is placed before the court. Perusal of the minute reveals that although the DLC held that no vacancies are available for recommending the appointment of the petitioner, but the executive engineer of the concerned division was permitted to take suitable action under clause 15 of the OM dated so and so by sending the pending proposal to the head of the administrative head of the administrative department. Stop. Para. Clause 15 of the OM reads as under. Para. Again, a perusal of clause 15 as well as a perusal of the minutes placed before the court dated 31/12/2021 reveals that the guidelines at the clause 15 of the guidelines requires the consideration of any applicant's case in respect of vacancies that may be available in other administrative departments, and in the event the vacancies are not available in the department through which the proposal was submitted. Stop. Thereafter, the DLC will consider the matter and pass appropriate orders on the said proposal. Para. The minutes of the meeting held on 31/12/2021 does not reflect that this the provision of clause 15 of the OM dated 1/6/2015 was complied with. Stop. Although the executive engineer was directed to take suitable action and take up the matter with other heads of department in respect of any vacancies that may be available, no such order has been passed by the DLC as on date. Stop. Under such circumstances, prima facie we find that the directions contained in the order dated so and so have not yet been complied with, although the same was required to be complied with within a period of 3 months from the date of receipt of a certified copy of this order. Since the Learned Counsel MSK Fukan prays for a short date to complete her instructions in respect of respondent number 5, who is impleaded subsequently in the writ petition, we grant one opportunity and permit the Learned Counsel to bring it to the notice of the concerned officer the directions contained in the order dated so and so, passed in WPC so and so. We hope and expect that the authorities concerned will comply with the directions contained in the order and file an affidavit of compliance thereto by the next date fixed. List on 18th October.
One more thing, my lord. Prior to that DLC, my lord, there is a DLC on 6/6/2020, my lord. That was also not considered.
Let them file their affidavit, we'll see.
My lord.
Yes, other matters left over. My court master says only 10 matters, so do it before you rise. So yes, hold up.
My lord,
This is a contempt petition, my lord, and order is dated 17/2/2023.
my lord,
And the honorable court directed to reinstate me in service. The direction is at page 18, my lord.
Yes, Mr. Nath.
my lord,
Speaking about it, my lord.
my lord, in this matter, I prefer further 1 week time.
No, my lord. I object, my lord. It should take, appeared on, my lord.
No,
Notice was issued on 17/5.
Lord.
He appeared on 9/8, my lord. And what?
All right, all right. One week's further time. 10 days further time granted to Mr. D. Nath at his prayer to complete his instructions in stop. Mr. J. Patwari, however, submits that in spite of opportunities granted earlier, the directions contained in the order dated
17/2/2023 at page 11.
17/2/2023 passed in WPC 682 of 2023 has not yet been complied with. A writ petition, contempt petition accordingly stands adjourned to be listed again on 18th October.
My lord, in the other contempt matter, my lord,
46.
in the other contempt matter, my lord, that copy of the minutes. My lord, just will take a copy of that.
Yes, yes, you take a copy.
My lord.
Wait, please, your lordship. This is the fresh case, my lord.
Yes.
Contempt petition, order dated 18/11/22. Page 11. 16 letter.
Heard learned counsel for the parties, this contempt petition arises alleging willful disobedience of the directions contained in the order dated so and so, passed in WPC so and so. Issue notice, returnable 4 weeks. Steps on the respondents by registered post 80.
By tomorrow.
List after return.
Hello.
Please, your lordship. You contempt Case 11 lordship. Order. That is 22/3/20.
Sorry?
Page 11 lordship.
Yes, yes.
Order dated 22/3/2023. Relevant portion at page 12 lordship.
All right. Notice returnable 4 week steps on the respondent by registered post 80. After 4 weeks, details in order to be. Yes. Yes.
Your lordship, if this matter may kindly be taken up on next week, any day.
At the request of Mr.
Abhijit Kakoti.
A. Kakoti, matter stands adjourned for 1 week. List accordingly.
Deeply obliged.
Wait, please, lordship.
Yes.
Contempt matter. Lordship may kindly peruse the last order 14/9.
In this case, lordship, finance has sought some clarification from us, lordship. So matter is pending before the finance. Until and unless it was approved by the finance, we cannot tell, lordship.
Lordship, that was the instruction last occasion also on 14/9 and multiple occasions before that. also.
Multiple
Where is the direction of the court?
14/9, my lord.
Page
Last-
number.
Oh, order, my lord. Page 28, my lord, of the petition.
Page 28.
28. Para 23, my lord. The respondents are directed to pay the petitioners the basic scale of pay, including the arrears, with effect from 22/1/2015 within a period of 3 months. 2018 matter. my
It
lord.
was already fixed by the cabinet, lordship, but it will be some 2,000 rupees should be enhanced, lordship. So it was only that particular reason it was pending before the finance, lordship. Otherwise, lordship, if he wants to take the less amount, then lordship, it is ready, lordship. Only 2,000 rupees should be enhanced, so it was pending for the finance, lordship.
Whatever you have to do, you do.
Lordship.
The direction is to comply within 3
lordship,
months.
That part I have already given the lordship the orders which are in a file itself, lordship. Honorable Court's file itself. I have already earlier submitted.
What have you given?
Lordship, the compliance, Lordship,
Ah,
it was already submitted before the Honorable Court, Lordship. It was also there. Hey, this is the Lordship after Honorable Court's order, Lordship, it was announced by the government. But Lordship, some 2,000 rupees to the other announcement is required.
whatever
So,
is required, you enhance it, but
Lordship,
the
then-
compliance of the order should not be
Compliance,
held up because of
otherwise-
this.
Otherwise, Lordship, as per court's order, we have passed that order, Lordship. And Lordship, the net slate part also we have enhanced 3 years as per court's order, Lordship.
This order is complied with.
My lord, no, the disbursement of the salary, that
Disbursement,
has not been
disbursement amount, Lordship, it should be the DDO, Lordship, not for us. DDO is the principal of the college, Lordship. So principal is the college has to, Lordship. You have to submit the, Lordship, the bill, then the authority will process, Lordship.
The finance has been made a party here.
Finance is regarding that part, finance not, Lordship. For Lordship, regarding area salary, DDO should be the party, Lordship.
My lord, I believe finance was the last authority waiting for the deciding here. That is what was submitted, my lord, on the last.
Where is the order again? Page number 16.
Lordship,
16 to
Lordship,
28.
Lordship,
No, it begins with page 16.
16.
Lordship,
So the respondent was whom? The Commission, Higher Education Department.
Lordship, Lordship,
So the direction was issued to Higher Education.
Lordship.
Lordship, later on, an I was filed for impeachment of parties. That was also done, my lord.
We don't know.
My lord, I-1326, that was disposed of. That is also not reflected in the file, but through that, my lord, respondent 4, 5, and 6 were also impleaded.
There is a
And in respondent 6, that is Jayanta Narlikar, that is the Commissioner Secretary of the Department of Finance, my lord.
There was a, my lord, two direction, Lordship. One direction is, my lord, may kindly page 26, Lordship. Two full direction was there from the Honorable Court, Lordship. Page 26, Lordship. First paragraph, above, Lordship. Paragraph number 20, Lordship. The last 2-3 lines, Lordship.
Yes. Please read.
Lordship. The condition number 3 of the order dated 22/1/2015 does not provide for a period beyond 2 years for acquiring net and slate. A corrigendum or a new notification should be issued by the state respondent extending the time period of 2 years given for the acquiring net and slate to 5 years, Lordship. That was also done as per Lordship's direction, Lordship. We have enhanced the another 3 years period, Lordship. Then, Lordship, the other parts also, Lordship, we have done, Lordship. Other part is, Lordship, page 28, Lordship. That was also fixed by the authority, Lordship. Now, area part, Lordship, the DDO of the concerned college has to submit the bill, Lordship.
Why do you say it is not complied with?
My lord.
Why do
My
you
lord,
say
the
the
last
order is
part,
not
that is-
complied with?
The last part, that is para 23, my lord.
Hmm.
That the direction for to the petitioner to be paid the basic scale of pay with effect from 2015, that has not been complied with. The directions on page 28, para 23.
What is your basic scale of pay?
My lord, that was the question that happened on the last occasion during it. They have submitted a corrigendum which stated way less basic scale of pay at that moment, which was then
It
to
should
be
be,
paid.
Lordship, 15,600, Lordship.
But that enhancement has been brought, and
So
that
this enhancement has also been enhanced.
Yeah, that was 50, now
not disbursed, my
55,000,
lord.
Lordship.
Disbursement has yet to be done.
Disbursement is so, Lordship, for the DDO.
Disbursement, who will disburse it?
It's by the DDO, principal of the college.
Your
has to
bills
submit
will have to be submitted.
Lordship.
My lord, then that direction, my lord, I'll do the
What
necessary.
directions? You go and talk to, you go and approach your authorities who will prepare the bill and send it.
My lord, then we'll do the necessary. We'll keep it open, my lord. We'll, in the meantime, we'll do the necessary.
Matter stands adjourned for 2 weeks, enabling the learned counsel for the petitioner to complete his instructions in respect of the disbursements sought to be yet to be made to the petitioners. In terms of the directions of the court by order dated so and so, passed in so and so. Yes. Yes.
I'm Victory Lordship for non-compliance of order dated 25/7/2019. However, this honorable court directed a response number more particularly.
Here on the last date, Lordship had granted us 2 weeks time, which is what Lordship, I had sought instructions from the department by 4th of October, my lords. Because this matter has come up after 11 days, my lords. That's why the instructions are not there. This is, I tried to mention this in the morning, Lordship.
Mr. A. Choliha is permitted another 2 weeks time to complete his instructions in respect of the compliance of the directions contained in the order dated 25/7/2019, passed in WPC 3731 of 2018. Mr. A.K. Dotto appears for the petitioner. In the event no concrete steps are found to be taken for compliance of the order, consequential orders may be passed by the court on the next date fixed.
The date may be fixed, my lord, 2019 meters, my lord. They are waiting for
8th of November.
obligement.
Yes.
Lordship, kindly peruse the last order, 28/5/2022.
4 weeks. Prayer of the counsel for the petitioners.
No, 28.
28/4.
Hey, তুমি কি করলা? Lordship, another order is there.
28/4. 6/2. You are given 1 week's time for fresh
No, my lord.
fresh steps.
25. 25.
Yes.
In this matter, in compliance to the earlier order, my lord, he was regularized.
Complied my order. The petitioner wants
Now
not
he
get
is-
the arrears.
Now
my lord.
petitioner is seeking arrears salary, my lord.
Where is the direction of the court?
My lord, inspector school has already been submitted, my lord.
No, where
He
is the
replaced me.
where is the direction of the court?
Yes, Lordship, kindly peruse the order dated 28/9/2019. 28/5.
2009/2019.
Yes, my lord.
Then what is the direction?
Speaking order and again the
Order,
benefits
last
and-
order, Lordship, with the above section, second para, page 10. তাৰপিছত the Provident who has been working as scheduled employee.
So direction of the honorable court is let the respondent authorities do the needful to implement the speaking order
Yes.
and grant the benefits and contemplate the aforesaid order.
The order.
Already he is regularized. My lordship.
Regulars long back. After that, they did not do anything, my lord.
But this order is complete. This is the order.
Yes,
No,
madam. And
Lordship,
regarding the
Is there any
salary,
direction
finance
for
is-
area salary? Nothing.
Earlier,
Of
he
course.
was appointed as a casual employee, my lord, in a leave vacancy.
You'll have to file something.
yes, my lord, I want to file. My lord, inspector school have already been submitted. Oh, Lordship, I'll file a press petition.
Submitted by the,
To this contempt.
you can't withdraw, we'll close it.
Yes,
It is submitted by the learned counsel, Mr. Sharma.
You, Sharma.
U. Sharma, government advocate, that the directions contained in the order dated so and so has been complied with on
It is complied, my lord, he is already regularized.
has already been regularized.
Yes.
Stop. The learned counsel for the petitioner, MSK Devi, does not dispute this contention and submits that she has already.
actually, this line is there. Let the respondent authority to do the needful to implement the
Yes.
speaking order and grant the benefit as but that benefit was not
Okay.
getting. That's why I have come, my lord. That benefit was, my lord.
What is the benefit in that order?
my lord,
He is regularly getting the salary, my lord.
getting the
now.
salary, getting the salaries, my lord.
Real salary on extra.
Arrear salaries, my lord.
Where-
And
where-
Lordship, kindly peruse the inspector of school has already been forwarded all documents to the director. Then your lordship,
Uh,
the-
all right. Submits that he has already been regularized. Stop.
long back, my lord.
However, his area salaries have not been released.
Released, yes, my lord.
Uh,
That aforesaid exercise shall be completed within a period of 2 months
The
from the date of.
perusal of the order dated so-and-so passed in WPC so-and-so reflects that a decision having been taken by the competent authority, the direction was issued to implement the same
Yes.
and grant benefits as contemplated in the order within a period of 2 months. Accordingly, the respondents are directed to address the claims of the petitioner in respect of any other benefits available and process and release the same as expeditiously as possible.
Yes.
The entire exercise be carried out within a period of 120 days from the
20
date of
days, my
receipt
lord,
of
it
the
is
order.
So short. 20 days is so
120.
My lord. 100, yes. Yes.
Matter disposed of on
Highly obliged.
contempt petition stands closed. Terms of the above.
We could not. Very good.
Yeah, please, Lordship.
Order complied. Order complied.
So the kindly peruse the order dated 21/8/2023.
Have you taken steps?
Yes, my lord. The steps already have been taken.
AD card await service report on respondent 5 list after 2 weeks. What is this?
It's a postal track report.
The office note says service not complete.
But in registry, we have submitted.
It is submitted by the learned counsel for the petitioner that postal track records reveal that the service has been complete. Registry to verify and make necessary order endorsement and in the office note and place it before the court after 1 week. Yes.
Can I have it on 5th of October, my lord?
Very difficult.
10th.
Right, we'll try on 10th.
On 10th, my lord.
10th. Why this matter was been pending for so long?
The promotion is pending, my lord.
Two 2014, then 2019. 5 years matter was not listed. There was no mention or no mention was made, no application was filed. List on 10th.
10th.
As agreed to by the learned councils. Yes, Mr. Tiwari.
Could it be on 16th of November? I'm asking a long date.
16th of November.
16th November.
As the matter be listed for hearing on 16th of November. As agreed to by the learned councils for the parties.
The matter has already been passed.
See, there is nothing here to suggest as to why the matter was not listed and so on and so forth. When was it listed last?
2015, after the 2015 order. Actually, the petitioner, he is from UP, Uttar Pradesh. So from there, he was unable to contact with the then counsel who was engaged. And the matter was showing as disposed in e-court. And later on, when I was engaged in 2022.
No, matter was showing disposed where?
In the e-court. Means, for him, it was not possible to verify physically coming here and verify. He was going to the e-court, and there only he saw that the matter.
The
was-
matter was heard on 29/9/2023. During the course of the hearing, it is revealed that pursuant to 7/1/2016, the matter has not been listed. Sorry, 23/2/2016, the matter was not listed for a long time. It was thereafter listed on 2/9/2022. Learned counsel for the petitioner submits on instructions that when inquiries were made in the registry, the petitioner was informed that the matter was shown to be disposed of. However, no such judgment or order was made available by the registry. Subsequently, on steps taken by the newly engaged counsel who's presently representing the writ petitioner, the matter has been listed before this court. Mr. So-and-so appears for the respondents. You are appearing for?
Doctor, I'm appearing on behalf of respondent number 4.
MS so-and-so appears for respondent number 4. Who is respondent 4? The person. One of the candidates. He's there or he's not there anymore?
According to the information yesterday, they have given only respondent number 4 is there.
Okay, on behalf of respondent 4. Considering the fact that taking note of the submissions made by learned counsel, Mr. M. Dasgupta. The registrar judicial is directed to cause an inquiry as to the delay, as to the substantial delay in listing the matter before the court between 7/1/2000, sorry, 23/2/2016 and 2/9/2022. The report of the inquiry caused be placed in a seal cover, placed before this court in a seal cover. Matter stands adjourned for. Let us see what happens in the report. What comes out. We'll take it up. On 13th October. 13th. List on 13th October. Copy of this order we mark to the Registrar Judicial for carrying out the directions.